The writ appeal is dismissed.
Oh, that's right.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 4. On behalf of Senior Counsel, Mr. A. Apang. Lordship, I'm kindly seeking for an adjournment as he could not appear before this court today.
Have you taken the consent of the other?
Yes, Your Lordship.
When do you want it?
Your Lordship, after a week.
After a week?
Yes, Your Lordship.
All right. Mr. A. Apang, Learned Senior Counsel, appearing for the petitioners, appearing for the appellants. He said to have some personal difficulty to appear before the court today. Stop on a mention made on his behalf and not objected to by the other side. Matter stands adjourned for a week.
Much obliged, Your Lordship.
Yes.
Yes, my lord. I beg to mention item number 9, my lord. On behalf of M. Biswas, my lord. I consent from my lord other side.
On behalf of?
M. Biswas, my lord.
Okay. Yes.
Yes, matter my lord fixed for 26th of this month, my lord.
Who's for the other side? They agree to that 26th. All right. What is the difficulty?
No, but as per my lord instruction, my lord. Yeah.
Now, why is he not here? Any difficulty?
This is what he best by advocate, my lord.
There must be a reason behind that he's sick or he's unwell or has some personal
He is,
difficulty.
my lord, ill, my lord.
Sorry?
Ill, my lord.
Okay. Mr. M. Biswas, Learned Counsel for the petitioners, is said to be indisposed. On a mention made on his behalf and not objected to by the other side. This is the matter. On 27th,
26, my lord.
26th of March, 2025. That's paid for. All right.
Okay.
May I, Your Lordship? I beg to mention item number 2 on behalf of my senior counsel, C. Modi, who is presently out of station.
Yes.
I pray to release this matter after 3 weeks.
2 weeks.
3 weeks.
3 weeks.
Yes.
Okay. Mr. C. Modi, Learned Counsel for the petitioners, is said to be out of station. And on a mention made on his behalf and not objected to by the other side, matter stands adjourned for 3 weeks.
Much of.
Yes. No one is there for the appellant.
Nobody is there.
What are they challenging?
My lord, otherwise also this case, the petitioner in the writ petition challenge the non-construction of road by the national highways. So they divert the alignment. So when it was abandoned, the RWD on the request of the Honorable MLA, they take over the road under PMJS roads. So RWD has nothing to do otherwise also. Earlier direction was given to PWD. For that contempt was also filed and it was pending before the principal seat.
Anyway, since the appellant is absent, so we'll post it again after a week.
Otherwise also that there remains nothing, it remains there.
That will be considered. Let them appear. None appears for the appellant when the matter is called. However, Mr. G. Tara, Learned Standing Counsel, RWD, and Miss
Lordship 3.
G.
Yes, sir.
You are for the trees,
One,
Learned
1, 2,
Senior Government Advocate,
Additional
3,
Additional Senior Government Advocate appears for respondent numbers 1, 2, and 3.
1, 2, 3, no.
List the matter again after a week.
1, 2, 3.
Yes.
Always.
May I please, Your Lordship?
Yes.
My lord, this matter is regarding prayer for grant of remission. Uh,
Remission,
yes, remission.
under what provision?
Under the provisions of the erstwhile CRPC, now BNSS,
Ah.
there has been a recommendation for remission from the prison authorities. Everything has been done. Also, it's been sent to the government. Government is sitting over the matter. It was sent way back in 2022. As per the order dated 23/1/2025, this honorable court was pleased to issue notice, and affidavit was to file early. That has not been done.
See, Ms. Dungan.
Yes.
see, I believe the remission is the.
It is the executive
it
function of
is
the state.
executive
Yes,
function.
we are only seeking consideration of the same by the executive authorities. It is a settled law that although it is an executive function, the court can issue direction for exercise of the same if it is not done.
Hmm.
It is not that the court will give an order for remission.
Can you show us the recommendation made by the prisons?
Yes,
There must be a committee or a board
yes, the recommendations will be done. Everything has been done.
recommendations done by the committee.
Prison authorities, committee.
No,
Lordship will
committee,
see at page 26.
committee will comprise of not only the prisons, but will comprise of other authorities also. From the Home
Lordship, page
Department and
26, Lordship.
26.
Six. Superintendent, jailer, assistant jailer.
No, this
Then
is,
also matter was sent to the convicting court, and the recommendation is also there in his favor.
no, see, Ms. Dungan,
Yes,
now you have shown me only that jailer, assistant jailer, superintendent, these
Yes.
are all the jail authorities.
yes, they are supposed to, Lordship. What I'm saying is, after all these recommendations are done, the government is supposed to constitute a committee and then to look into the matter.
Exactly.
Yes,
See, you're
that has
saying-
not been done.
No, you're saying that he's supposed to constitute a committee.
Yes.
Is there not a committee already constituted by the state government to look into this kind of matters?
Lordship, not in this
Or-
case, not in
Or
this,
as and when the case comes, only then they constitute a committee like that?
not in this case, but there are various there have been various convicts who were granted remissions
By
by
whom?
by the government by constituting
Can you
committee.
show
Yes.
us any of those here?
I don't have it at the moment, Lordship. One,
This way,
yes,
this may not be an individual case.
yes,
Committee is concerned with all the cases.
yes,
Whoever are entitled to get
Yes.
remission,
yes,
they will sit and consider
yes,
and accordingly make the recommendation.
yes,
So it is not that one person has applied for it and they will specially consider it for him. Now, the documents which you have shown us is
Yeah.
basically from the jail.
jail
They
authority.
may initiate.
Yes,
Ultimately, it's the committee who will take a call.
that was initiated way back in 2022, and Lordship, this was
Anyway,
sent to the government by page
Why-
22 also.
Why is it listed today?
Today is for the response of the government.
Yes, what do you say?
We were supposed to file this affidavit notice.
Ah,
We didn't file the affidavit.
you were supposed to file.
Yes.
Why you
We
did
did the
not file?
party,
Huh?
this secretary home and this thing.
You are representing Secretary Home. Whom are you representing?
Yes, I am representing this secretary and SP.
So what
From
is your
government.
instruction?
Instruction I had said,
Hmm?
not that we haven't got any this instruction yet.
You have not received any instruction.
And she submitted that from the convicting court also.
Hmm.
Let them come.
Convicting court also, you got the recommendation.
Yes.
And we have any is also they could.
Lordship, I will also take instructions on in other cases in wherein remissions were granted by constituting committees. That I'm aware of, but the particular case I'm not aware of. Matter has come to the Supreme Court also. In the Supreme Court had also taken note of this, and later on it was told to the Supreme Court that informed that this person that one person remission has been already granted. So that is how I know that there are some cases. So
Okay.
let government come up with instructions, or better if they file an affidavit.
Definitely, they'll have
Yes.
to, we want them to inform us also what kind of committees
Yes.
constituted.
Yes.
So that we can, take further steps. What is your good name?
L. Lawang.
L. Lawang. You are the PP?
No. I'm senior government advocate.
L. Lawang.
Yes.
You represent both the respondents,
Yes.
state represented by Secretary Home and the Inspector of Prisons, Inspector General of Prisons. Both.
Inspector General, yes,
You have not received instructions
No.
till now.
till now.
Okay.
We were asked to this thing obtain for some more time. Well, okay.
Yes. So, please write down. Art Miss N. Dungan, Learned Counsel for the petitioner. And Mr. N. Lawang, Learned Junior Government Advocate. Junior or senior?
Senior.
Senior.
Yes.
Learned Senior Government Advocate. Appearing for the respondents. So it is the case of the petitioner that although he has been recommended to be granted remission by the prison authorities as well as the court which has convicted him, the state respondents are not taking any steps to consider granting him remission, and therefore he has filed the instant writ petition. Stop, although notice was issued
23/1/25.
23/1/2025, the respondents have not yet filed their counter affidavit. To stop. On the prayer of Mr. L. Lawang, Learned Senior Government Advocate. Further, how much time? 2 weeks time is granted
2 weeks. Yes.
to obtain instructions and to file counter affidavit.
Yeah.
Stop. The Learned Senior Government Advocate by the next date shall also inform the court as to whether any committee has been constituted by the state government to consider the remission of prisoners. And if such has been constituted, a copy of the notification or order in that regard should be produced before the court. The Learned Senior Government Advocate shall also inform the court as to whether the case of the petitioner has been considered for remission of the sentence imposed upon him, and what exactly is the stage by the next date.
Yes.
You'll file an affidavit, but we want these instructions also. Okay.
Yes.
List the matter again. On 27th of March.
Lordship, can it be on another date? I will be out of station.
Okay, on 2nd of April then. 2nd of April, Wednesday.
Can it be on 4th of April?
It's a Friday. 4th of April, 2025. A copy of this order be furnished to Mr. N. Lawang, Learned Senior Government Advocate, during the course of the day to enable him get the instructions.
Obliged.
Yes.
Item number 6. Lordship, as per the last order dated 4th February 2025, we have taken steps on 7th Feb 2025 upon the sole respondent. I am appearing on behalf of Mr. B.K. Singh.
Okay.
My lord, I am appearing for the respondent, my lord.
Respond number one.
Yes, my lord. Sole respondent.
So respond.
Yes.
Okay, that's good. What's your good name?
El Nosi.
L
Nosi.
Nosi.
Yes.
NOSI.
Yes. My lord,
Okay.
I'll file objection, my lord.
How much time?
3 weeks.
What is your good name? Miss,
Lordship S. Sharma.
okay, Miss S. Sharma, learned counsel for the applicant appears through VC and submits that service report upon the respondent number one is awaited. Stop. At this stage, Mr. N. Nosi, learned counsel submits that he has instructions to appear on behalf of the sole respondent and he may be granted 2 weeks' time.
3 weeks.
Have you filed your power? Power at Bakalatnama.
No, not yet. I'll file.
When
today.
will file? Today.
I'll file today.
And he submits that he may be given 3 weeks' time to file objection to the IA. To stop, he further submits that he will be filing his power within the course of the day.
Okay.
To stop, in view of above, list this matter again after 3 weeks. Respondent to file objection. In the meantime,
Obliged, Lordship.
October 7.
May I please, your lordship?
yes,
Lordship, as per the last order, we have taken step upon the private respondent dated 10 February 2025. It was supposed to be taken on private respondent number 2, your lordship.
February.
Yes, your lordship.
Which respondent? Number two.
Upon the private respondent number 2, your lordship.
Number two.
Yes, your lordship.
Okay. Anyone appearing? No one.
Two lordship, service has completed lordship, but no one has appeared in. It's a
Service
private-
complete.
Yes, lordship. As per the record, service is completed, lordship. Upon respondent number 2.
It's placed on record. This service is by usual service, is it? Now, what is this appeal about?
Lordship, this appeal is against the conviction
Under what?
under 374-2, your honor. And then the IA is for condoning the delay, your lordship.
Respondent number one is the state.
Yes, lordship.
Number two is what? The informant?
It is
Informant,
lordship.
your lordship.
Informant.
Yes, lordship. Lordship, for the hearing for the
Whatever. Some emergency. Huh? Yes, you were saying?
Lordship, for lordship, for condoning the delay lordship, the other party lordship should be heard lordship because it's a section 302. This is the lordship,
Maybe, but person is in jail.
lordship,
Person is in jail.
lordship,
He may
convict.
file appeal at the last minute also. But thing is that person is in jail, his liberty is curtailed. Should we take a very strict view on that? How many days delay?
Your lordship, it's 2,411 days, your lordship.
2,411.
Yes, your lordship.
He's convicted for life or what?
Yes, your lordship.
Hmm.
The reason we have already placed before this,
It's a jail appeal. Is it a jail appeal?
yes, your lordship.
Your legal aid counsel?
No, your lordship.
It's a.
The legal aid counsel were appointed, but none of them had actually filed the appeal. So this was in 2025 January when he was given on parole, your lordship, for 20 days. That's when he approached, because the reason we have placed before this honorable court that there were 3 legal aid counsels those were appointed, but none of them has filed the appeal, your lordship. So having no other alternate, he had approached through a relative, your lordship.
So you are engaged separately.
Yes, your lordship.
What do you say? Can condone the delay. What is that?
Is it even being-
Hmm.
And also, your lordship, the convict from the date of his arrest till date, he was never released, your lordship, not even in bail.
Sorry?
The convict, your lordship,
Hmm.
from the date of his arrest
Hmm.
till the recent parole, he was never released, not even in bail, your lordship.
It's a heinous crime,
Yes, your lordship.
isn't it? But and nevertheless, he has a right to file an appeal so that the matter can be considered by the appellate forum. Now, where is the order of conviction?
If your lordship will see, it's in,
Conviction
In-
is separate and sentence is separate, is it?
that was given on the same date, your lordship,
Same date.
on the same date, 23/6/2016.
Is that one of your ground also?
Lordship,
Is that one of your ground?
no, your lordship, that is not the ground. There were other grounds we have placed. That it should not be 302, but 304 part 2, your lordship.
So according to you, there's no illegality if the conviction is done and sentence on the same day.
That part I have not looked, your lordship, that would be my own opinion.
Okay. Your good name, please?
R Taku, your lordship,
R.
Taku,
EAPU.
TAKU, K,
EAKU.
yes, your lordship.
Art Miss So-and-so, learned counsel for the applicant, and Miss
L. Hage.
N. Hage. You are the public prosecutor,
Additional public prosecutor.
learned additional public prosecutor for the state respondent. Stop office note dated 3/3/2025 indicates that notice has been served upon the respondent number 2, who is the complainant. Stop considering the same. Notice is accepted to be complete on respondent number 2. Next para. By filing this application, the applicant prays for condonation of 2430 days in filing the connected appeal against the judgment and order dated 23/6/2016, by which he has been convicted under section 302 IPC and sentenced to go rigorous imprisonment for life and to pay fine of rupees 5,000 with a default clause. Stop. What is your explanation?
Yes, your lordship.
What is your explanation for the delay?
Your lordship, if your lordship will see, we have 5, that 3 different legal aid counsels were appointed for the 3,
Okay, then.
but none of the 3 have applied for this appeal before this honorable court, your lordship. So now, because he was going under the conviction, so only when he got the parole for 20 days in 2025, that's where he could approach his counsel to file this appeal, your lordship.
Okay, please write. Next para, the learned counsel for the applicant submits that 3 legal aid counsels were appointed to assist the applicant in filing an appeal before this court, but none of the legal aid counsels filed an appeal. Full stop. Therefore, it was only when the role for 20 days this year that he could engage the council. Full stop. The counsel for the applicant submits that ever since the arrest of the applicant, he has never been released on bail, except the 20 days of payroll that was granted to him. Stop. She submits that under these circumstances, the delay of 2430 days has occasioned, and the same may be condoned for the ends of justice. Next paragraph is Hage Learned, additional public prosecutor, on the other hand, submits that since the respondent has not appeared today, some more opportunity should be granted to the respondent number 2 to object the application, since the conviction is under 302 IPC. Stop. However, considering the fact that the applicant is in incarceration since the very day of his arrest, we are inclined to accept the explanation tendered in the application, and accordingly, the delay of 2430 days in filing the conducted appeal stands condoned. IA stands disposed of.
All right, sir. We know the Canada.
Please write down. In view of the order passed today in IA Criminal number 16 of 2025, the instant appeal is taken up for admission. Stop. By filing this appeal, no, cancel that. By filing, not required. You just write like this. Heard Miss So-and-so, learned counsel for the appellant, who submits that by filing this appeal, the appellant has challenged the judgment and order dated 23/6/2016, passed by the learned sessions judge, bracket WSD UPA, in sessions case number 55, bracket UPA/2014, convicting the appellant under section 302 IPC, and thereafter sentencing him to rigorous imprisonment for life and to pay fine of rupees 5,000 with a default clause. Can you tell us one ground that you have taken?
Yes, Your Lordship. The Lordship, one of the ground is 302 section. Whereas if we see the materials on record as well as the judgment passed by the trial court below, in that it has been clearly stated that there was the knowledge, but no motive was not there. There was no intention and motive was never proved. So when there is no motive, then it should have been 304 part 2, Your
All
Lordship.
right. The learned counsel submits that on appreciation of the materials available on record, it only appears that the prosecution has failed to prove that there was motive behind the alleged murder Full stop. If that is the case, conviction under section 302 IPC would not be justified. And perhaps the same would attract section 304 part 2 instead. Stop. Next para. In view of above, let the appeal be admitted. Call for the LCR. Issue notice to the respondent, Ms. Hage Lanet, additional public prosecutor, accepts notice on behalf of respondent number 2. Petitioner to take steps. Appellant to take steps for service of notice upon the respondent number 2 by registered post with ADD within 3 working days. List the matter again on receipt of the LCR.
My right, Lordship.
Yes.
Your Lordship, why an order dated 1/10/2024, Your Lordship? The status of the examination, re-examination, fresh evidence and further evidence that was directed from this court, Your Lordship.
Yes.
Your Lordship, why communication dated 8/10/2024, Your Lordship, the trial court has given the status that it's at the stage of evidence, Your Lordship.
Since when?
The,
That was 2 years back.
yes,
Direction was given 2 years back
yes,
on 7/4/2022. And suddenly this case surfaced back in 1/10/2024 after more than 2 years.
yes.
Then court wanted to know what is the stage. And now the court says that it is at the evidence stage.
Yes, and the communication is also.
And how
dated-
many evidence means who are supposed to be examined again?
That, but specifically has not been, there's no specific direction to that, only a direction for further evidence, Your Lordship.
Hmm. And the LCR is still retained by the trial
Yes,
court.
yes.
What do we, what is?
Even after 2 years. Because otherwise it's spending. The recording of the present. Now again, we have to give a direction to the code below. Send back the question, otherwise we can follow.
Parties are represented by the respective councils. Stop at the outset. Miss, your good name?
Tijini, Your Lordship.
E. Jeannie.
Yes.
Lanet, additional public prosecutor.
Yes,
Submits that. In terms of the last court's order dated 1/10/2024, the district and sessions judge Upia Papumpare has informed that the case is at the evidence stage. Stop. However, we find the same to be however, we find that the learned court below has not given the details of how many prosecution witness or otherwise have been examined so far? And how many are still left to be examined? Stop such being the position, registry shall call for further details from the court concerned about not about, from the court concerned as to how many witnesses have been examined so far and how many witnesses are yet to be examined. Let the case be listed again after 2 weeks on a date to be fixed by the registry.
Deeply. To mention item number 5, Your Lordship, this matter may be listed after next week, Your Lordship. I've informed
Any
Your
objection?
Lordship.
I'll say.
Yes, I've informed Your Lordship.
As paid for by Miss
P. Pangu, Your Lordship.
P. Pangu, Lanet State Council, and not objected to by the side. Matter stands adjourned for a week.
And also item number 2829, Your Lordship. This matter may be listed after 3 weeks.
These are clubbed together. Have you
Yes.
informed the other side?
Yes, Your Lordship.
Why do you want adjournment?
Yes, in this matter, senior government, as Tapin is appearing, he instructed me to adjourn this matter. He's out of station.
Mr. S. Tapin, Lanet, Senior Government Advocate, appearing for the state respondents, is said to be out of station. And therefore adjournment has been prayed on his behalf. Stop the said prayer is not objected to by the other side, and therefore stands adjourned for
3 weeks, Your Lordship.
3 weeks.
Yes. And also item 10, Your Lordship, same order, Your Lordship.
He's also Mr. Tapin.
Yes, Your Lordship.
Okay, item 10, similar order.
Oblige.
Yes.
Yeah,
Right.
I'm updating my, private response was 7, 8, 9, and 10. So I have already filed affidavit of 7, 8, and 10, but 9, I yet to file 9. Well, I need some more time to file.
Okay,
I have taken counsel from the petitioner.
your good name,
And now,
Mr. N. Rama, Learned Counsel, for respondent numbers 7, 8, 9, and 10, submits that he has filed the counter affidavit of the respondent he represents, but not on behalf of respondent number 9. Stop, he submits that he may be given how much time? 2 weeks time to file the counter affidavit of respondent number 9. Stop. The said prayer is not objected to by the other side. And therefore let the matter be listed again after 2 weeks. Yes.
Manoj, I beg to mention item number 7.
7.
Yes, ma'am. Manoj, this matter may be listed after 1 week, madam.
You are for the,
Petitioner, madam.
why, what is the reason?
Reason, Manoj, is,
Mr. Saikia,
yes,
Mr. R. Saikia, learned counsel for the petitioners, is said to be indisposed on a prayer made on his behalf and not objected to by the other side. Matter stands adjourned for a week.
yes, ma'am.
All right.
God bless you.
I'm taking a concern from the other side. Can it be maybe on second April of second April?
As paid for on behalf of Mr. A.K. Prakash, learned counsel for the petitioner and not objected to by the other side. List the matter on 2/4/2025. Yes. Similar order. Okay, same order in item 18 also. Yes.
Lordship, I would like to mention item number 9, Your Lordship, on behalf of Estapin Senior Government Advocate, Your Lordship. I kindly take up this matter after 2 weeks, Your Lordship.
Have you informed the other side?
Yes, Your Lordship.
Yes, any objection?
They should have the instruction on affidavit.
Okay.
Because we have long pending matter.
What is the issue regarding?
Regarding non-registration of an FIR by the SIC, where allegations has been leveled for misappropriation of government fund by government officials.
They have not filed affidavit?
Not.
Not yet, Lordship.
The
Okay.
instruction,
Whether instruction has been received or not, Your Lordship, I'm not aware of it, Your Lordship, since Estapin is appearing in this case, Your Lordship.
If he has received, let him file. If he has not received, let him ask and file. We'll grant you 2
Lordship.
weeks time.
Lordship.
let
Mr.
them bring it on record.
Sorry?
Let them bring it on record. Whatever.
Exactly, exactly. You want a date on this?
After 2 weeks.
February,
8 of
8th of February,
April.
April.
April, okay. All right. Prayer has been made on behalf of Mr. Estapin, learned senior government advocate, for adjourning the matter for 2 weeks on the ground that he has some personal difficulties. Full stop. Mr. B. Kaushik, learned counsel for the petitioners, on the other hand, submits that the respondents are yet to file their counter affidavit. And therefore submits that they may be directed to file their affidavit within the file their affidavit. Since the allegation made by the petitioners is that the respondent authorities have failed to
Registered and filed.
register an FIR against the allegation made against certain government officials. Considering the submission, let the matter be listed again on 8th of April 2025 as paid for. The respondents to file the proper affidavit in the meantime.
Lordship, one more item, Your Lordship. Item number 11, Your Lordship.
Yes.
May I kindly take up this matter after 2 weeks, Your Lordship. Here I have to file affidavit on behalf of respondent number 2.
Any objection?
They may file the things as soon as possible, because the pensioner, the petitioner is not able to avail his pension for the last 1 year. It's been almost 1 year now. All they have to do is apprise the court of why the NOC is not being issued to the petitioner.
NOC for what?
NOC for pension, availing pension. The petitioner is a pension.
Correct, but NOC regarding what?
Pension.
No. There must be a purpose for giving NOC.
Vigilance.
Sorry?
Vigilance.
From the vigilance. There's one notification, isn't it? We have dealt with that matter also.
Yes,
One is towards pension and one is towards for promotion.
yes,
That vigilance thing is necessary.
yes. Lordship, 2 weeks, I'll file within these 2 weeks.
Mr. R. Basar, learned State Council.
One more prayer. By the next day, they must file the affidavit because the petitioner is facing a lot of difficulties because he's not availing the last 1 year.
That's what you already told me. You're repeating again and again. Miss R. Basar, Learned State Council, submits that she may be granted further 2 weeks' time to obtain instructions and to file counter affidavit. Stop. Your good name? Mr. E. Payam, Learned Counsel for the petitioner, on the other hand, submits that the petitioner has not received his pension, his or her, his pension for the last 1 year for want of NOC from the Vigilance Department. Stop. He submits that, therefore, the respondent should be directed to file their affidavit within a short time. Since, as the petitioner is suffering, considering the submissions made, let the matter be listed again on 1st of April,
No,
Good.
no, Lordship, on 8th, your Lordship.
on 8th,
Yes. 8th April, your Lordship.
on 8th of. They're in a hurry, Ms. Basar. Can you not get it
Lordship.
early before that? Okay, by 4th of April. List the matter, 4th of April, 2025. Stop if the respondents do not file their counter affidavit by the next date fixed. They should produce the relevant records for perusal of the court. Okay?
All right.
Madam, may I mention, my lord, item number 25 and 26 for accreditation, my lord, after motion subject to Lordship's convenience and subject to convenience of the bar member, my lord, since Learned AG is appearing on behalf of the state respondent.
No, let it go serially, Mr. Kato.
My lord.
Let it go serially. We'll see.
Since the other party, my lord, they are also from the Guwahati-based lawyer.
Maybe.
My lord.
No upgradation today.
My lord.
Yes. Any other mention? Unlisted matter, what is the urgency and what is the matter? Hmm. Hmm. No, what is the urgency? It can come up. What's some other day?
Lordship,
When do you want it?
today, after,
Today?
yes,
So what is the urgency?
Lordship, in the meantime, the respondent authority may further proceed with the recruitment process at any point of time, Lordship.
So what is wrong there?
So, Lordship, I am challenging the validity.
They have to proceed according to the advertisement. Why should they wait?
Lordship, basically, I am challenging the upper age limit
Okay.
of the
Upper age limit.
Yes, the upper age limit has been restricted to only 35 years.
Okay. And that debars you from participating.
Yes, that bars me from.
And how do you extend that 35 years to your
Lordship?
to your advantage?
Lordship, in normal cases, the upper age limit is relaxed to 40 years. In all cases, other cases, Lordship.
How? Is there any guidelines like that?
Lordship, in APSC examination also, on some other instances, the upper age limit has been made as 40.
40 years?
Yes.
For whom? For generally for everyone?
No, only for APSC candidate, Lordship.
APSC.
Yes.
Is there any guidelines as such?
Lordship, no such guidelines is there, but in many other cases, almost in all cases, the upper age limit is relaxed up to 40 years, Lordship. But in
Okay.
instant case,
Have you filed your writ petition?
yes, Lordship, I have modified.
Okay.
Deeply obliged.
May I please, your Lordship?
Yes.
Lordship, I beg to mention item number 20. So we have sought time for filing rejoinder to the affidavit in opposition filed by the respondent.
You still want some more time?
Lordship, no, there is no further instruction as such with regards to filing of the rejoinder application. So may I pray that this matter may be listed in admission column.
So you don't want to file rejoinder?
Yes, Lordship.
Your good name?
A. Tatak.
Mr. A. Tatak, Learned Counsel for the petitioner, submits that after perusing the counter affidavit, the petitioner will not be filing rejoinder affidavit after all. Stop. He therefore submits that the matter may be listed in the admission column. To stop in view of above, list the matter in the admission column after a week.
Lordship.
Okay.
Deeply honored.
My lord, I beg to mention item number 4.
Yes.
A matter may be fixed after 2 weeks.
When?
Leading counsel O Modi, he has a domestic problem.
Yes.
He has domestic problem. So he are
Okay.
not a petitioner. So leading counsel petitioner O Modi has domestic problem. So we have taken from the opposite parties.
Any objection from the other side?
No, your worship. I'm for respondent number 3 to 12 years.
Okay,
We
any
don't have
interim
any
order?
objection.
Any interim order? No.
No.
Prayer has been made on behalf of Mr. O Modi, learned counsel for the petitioner, to the effect that as he has some personal difficulties to appear before the court today, the matter may be adjourned for 2 weeks. Stop. Since the prayer is not opposed to by the other side, matter stands adjourned for 2 weeks. Yes.
Thank you.
Your Lordship, if I may mention item number 30 on behalf of Mr. Tarak. He couldn't make it today due to some personal obligation.
13.
30.
So when do you want it?
After I wake, Your Lordship.
Have you informed the other side?
Yes.
Yes, my lord.
Any objection?
No, my lord.
Okay, Mr. T. Tara, learned counsel for the respondents. Respondent?
Number
Which-
4.
Respondent number 4 is said to have some personal difficulties to appear before the court today. On a mention made on his behalf and not objected to by the other side. Matter stands adjourned for a week.
Yes, Your Lordship.
Yes, my lord. Interim order, my lord.
The interim order passed earlier shall continue till the next date of listing.
Obliged.
Yes, anyone? Top of the list? You are for the respondent.
Yes, my lord. I am responding.
Which respondent? All the respondents are present. Yes.
My lord, I on behalf of K.S. Subu, conducting counsel S. Subu is out of station.
Who?
Conducting counsel S. Subu, S. Koyang is out of station.
Yes, Koyang. Name is not in the cost list also. Oh, yes, Koyang,
S.
respondent.
Koyang. Sir.
Okay.
Person. Matter may be listed after 2 weeks. Letter was sent also there.
Okay.
My lord.
What is the matter about?
My lord, I am for the petitioner matter.
What is the matter about?
Letter.
You look very nervous. I don't know why. First time you are appearing.
Yes, first time.
First time you are
I did
appearing.
not.
You don't have to be nervous.
Read in matter.
Sorry?
I didn't read in matter.
You don't read the matter. You should read the matter when you seek for
I
adjournment.
did not read this issue.
You should do that when you make a mention before the court. Supposing the court asks you, what is this matter? At least you should say that this is that matter, this matter. That is necessary. Okay.
Okay.
Next time you go through at least the synopsis and tell the court, this is that matter like that. Although I'm not in the case, but this matter regarding termination from service or something like that.
Okay, okay. Sir.
So, Mr. Yes, Mr. or Miss? Mr. Yes, Koyang.
Koyang, sir. Yes, sir.
He has some difficulty. How much time do you want adjournment?
I don't meet S. Koyang.
Sorry?
I did not meet S. Koyang, sir.
You do not meet? Then how are you submitting?
My senior K. Tagyang sent to me.
You are mentioning on behalf of whom? On behalf of the respondent?
Yeah.
Or for the petitioner?
No, respondent.
Which respondent? Mr. Kamduk?
Yes, my lord, here I am for the petitioner, my lord. In fact, this matter has been pending since 2018.
You are for the petitioner?
Yes, my lord.
Oh.
In fact, the counsel for the respondent, Mr. Koyang, has called me up this morning, my
There's some
lord.
difficulty.
Yes, there's the difficulty, my lord. In fact, my lord, I have the pressure from the petitioner also, my lord. That's is why, my lord, this matter speaks on the top of the list, my lord. Since he is not available.
So which date you want?
Yeah, my
You
lord,
fix a date?
on 26th, my lord. And let it be on the top of the list again, my lord.
Mr. S. Koyang, learned counsel for the respondent, number
3 and 4.
3 and 4.
Yes, ma'am.
He said to have some personal difficulty to appear before the court today. And therefore adjournment has been sought on his behalf. Stop. Mr. D. Kamduk, learned counsel for the petitioner, has no objection to the prayer, but submits that the matter may be fixed on
26th March.
26th March 2025, since there is some urgency in the matter. Considering the submission, list this matter again on 26th of March 2025.
My lord,
Under the column, top of the list.
oblige, my lord.
May I please, your lordship?
Yes.
Lordship, in this instant writ petition, I have assailed the impugned notice dated 19/2/2025, whereby the authorities, respondent authorities has alleged that I have been obstructing in construction of tower 132, 132 of 132 kV line, transmission line at Kamke village. Now, this and then I have been directed to why an action shall not be initiated against me, lordship. Now, and another lordship.
Where's the order?
Order is at page 65, lordship.
What does it say?
It says that the concerned authorities has approached the petitioner for assessment and providing of rightful compensation, but he has not cooperated and resisted, adamantly obstructing the lawful developmental works.
Why are you obstructing?
Lordship, the facts, lordship, which I want to bring before this honorable court is, lordship, this particular initially before the initial survey, lordship, they have established an office in the vicinity of the WRC field of the petitioner, lordship. Now, this proposed tower is in the middle of the WRC field of the petitioner. So he has been asking the respondent authority to shift it somewhere else. And for that matter, he has in fact requested the authorities that he is going to provide alternate land, not only the instant petitioner.
That is verbally or in writing?
Lordship, that has been, we have made in the representation also.
Where is that representation?
Representation, in representation, lordship, it has not been specifically stated, but this representation was for, initially there was, while establishing the office, lordship, for the proposed tower line, lordship, there was certain damage was caused to the petitioner's WRC field. So this verification report is at page 52, lordship. This has been verified by the ADO.
Verification for what?
Verification for, since I have alleged that the respondent authority has damaged the WRC field, as well as certain waste materials were dumped in the WRC field of the petitioner, lordship. Now, regarding this, this was verified by the, initially complaint was lodged to the HGB. Thereafter, this verification was directed, lordship. Now, as per this verification, crop damage was found to be, correct and genuine, lordship. And
damage was done by cow cattle.
Yes, that was because of the temporary gate. It has been mentioned, lordship. It has been mentioned specifically, lordship. So this was the lordship initial thing, and thereafter, time and again, petitioner has been praying to shift the tower, lordship, because the WRC field, lordship, is the only source of sustenance, and not only the petitioner, other villagers are also been affected by this proposed tower line, Lordship.
Your statement, your submission regarding that you are ready to provide alternative land is not there in your representation.
Lordship, this has, although it has not made the part of the record, but that part we have already conveyed the same to the respondent authorities, Lordship.
What you are not pleaded, how can you submit that? You have to restrict your submissions to your pleadings, isn't it? That is the law. That is the rule. You want to raise some issue, you plead it.
Lordship.
If you don't plead it, don't submit. Doesn't make any sense.
Lordship, regarding this allegation in the notice, Lordship. So this petitioner is the one who have been approaching the authority for compensation. But here they have alleged that the petitioner has been not cooperating with the. Initially, there was no mention of 132. I mean, that installation of tower in the WRC field. In the vicinity of the WRC field of the petitioner, they have established an office. That's what that was the. I mean, because of that, petitioner was aggrieved. Now they have mentioned that they are going to install tower number 132 in the WRC field of the petitioner, Lordship.
Tower number
132, Lordship, page 65. And this notice was issued only after I have made this representation, Lordship, which is at page 60, Lordship.
See, was there any such kind of, is there any provision for compensating the landowner for erection of the tower? Is there any provision under the Telegraph Act?
Lordship, as under the Telegraph Act, Lordship,
Or they can come and install a tower wherever they want to.
Yes, that is what I'm saying. There is no provision as such in the Telegraph Act, but only Section 10. This notice has been issued under Section 10D, Lordship.
Yes, who's for the respondent?
I'm appealing for 1 and 2, my lord.
1 and 2 is the state.
Yes, my lord, state.
And who is responsible for installing the tower?
It's my respondent 3 and 4, my power grid, my lord.
Power Grid.
Yes, ma'am.
Do they have any standing counsel?
Power Grid, they are being represented by Shillong-based lawyer. In most of the cases, they appears.
They come from Shillong.
Yes, Lordship.
But this
Mr. Ratan, anything?
Mr. N. Khera, Nitin Khera is standing counsel for Power Grid.
But only when cases are there, he'll come. He's an outstation lawyer.
Yes, madam.
Locally, there's nobody.
Nobody.
So this notice is dated 19th of February 2015.
Lordship.
So what is your reply to this?
Lordship, this reply, it was not served to us properly. That has been collected through some other sources. They have been, it has not been served to the petitioner, Lordship. Only after filing of this writ petition that this copy of this notice was given to the writ petitioner, Lordship.
Only after filing?
Yes.
What do you mean?
No, I mean that copy was served. Initially, this that's why it is not even legible, Lordship. This has been
after filing of the writ petition, you got the copy. Then how come you have annexed it in your writ petition? And
Lordship, what I mean to say is that this copy was not served to us, but this has been, I mean, procured through some reliable sources. They have informed that such a notice has been issued, although that has not been served personally to the petitioner. So only after finding this notice, filing the writ petition, the copy of the same was furnished to the writ petitioner.
Now you have a copy?
Yes, Lordship.
Who has furnished it? Where is the copy?
This one, Lordship.
But this one is already.
Yes,
annexed
yes,
to the
I have been
petition.
told, I have been told that they have received the copy only after filing this one.
You don't have a copy. The
Yes.
original copy is with your client.
Yes, Lordship.
Prior to this notice, was there any such sort of negotiation between the Power Grid and the petitioner?
Lordship,
Any attempt? Since you have written some representation also,
yes, Lordship.
this was in January.
17, that was initially for the crop damage, Lordship.
What is this notice at page 42?
This is Lordship for the I mean dumping of waste material, Lordship. This notice has been issued by the HGB of Kamkil village, Lordship. Only after this the field verification was carried out by the ADO, Agricultural Development Officer. That is at page 52, Lordship. There it was found that the crop was damaged by the cattle who have entered.
Okay, please write. Third, Mr.
Etatu.
Learned counsel for the petitioner who submits that the petitioner being agreed with the notice dated 19/2/2025 bracket annexure 5 has filed the instant writ petition. Stop. The learned counsel submits that as per the said notice, the petitioner has been asked to show cause as to why legal action should not be initiated against him as per section 16 of the Indian Telegraph Act 1885 for having obstructed by the respondent numbers 3 and 4. Stop. The learned counsel submits that without prior permission or without paying any compensation, the respondent numbers 3 and 4 are intending to erect a tower for 132 transmission line in the very middle of his WRC. Next, para. In view of above, issue notice of motion returnable by 3 weeks. Miss P. Wang Mo,
Yes, ma'am.
learned government advocate, accepts notice on behalf of respondent numbers 1 and 2. Petitioner to serve requisite extra copies of the writ petition to the learned government advocate within 3 working days. Stop. Petitioner shall take steps for service of notice upon respondent numbers 3 and 4 by registered post with AD due within 3 working days.
Lordship, may I pray that the status quo may be maintained
The
till
next returnable date, status quo. As regards the notice.
No, as regards the installation of 132 tower.
Status quo as regards the installation of the proposed transmission tower in the WRC of the petitioner shall remain, should be maintained. List the matter again on.
10th April, my lord.
They'll be too far away. 3rd of April. Okay. All right.
Deeply obliged.
My lord, this is for issuance of LPC, my lord, whereas the person in those individuals who are the occupier of the same land alongside my land, my lord, they have been.
NOC for what?
NOC for issuance of LPC, my lord. In fact, my lord, for
Why is it required? NOC required?
it is required because, my lord, the village authority, they know exactly the position of the status and position of the land, my lord.
Who will give the NOC?
That NOC will be given by the village authority, my lord.
Village
Yes,
authority.
Gambur, GB and AGB.
For purpose of LPC?
Yes, my
For
lord.
grant of LPC?
Yes, my lord.
What are all these pictures? House pictures and all that?
My lord.
Photographs, what are these photographs?
Yes, these photographs, my lord, are.
This is your house?
Yes, my lord.
And you don't have LPC and you've constructed a house?
Yes, my lord, without LPC, my lord, because, my lord, this is my private land, my lord. Still, the authority are not giving me LPC because I could not obtain NOC from the village authority. Now the issue is, my lord, the village authorities, they are from one particular clan, my lord, which is Tripodia, my lord. So these village authorities, GB and HGB, my lord, they are issuing NOC to their own clan member only, my lord. But my case.
So you belong to a different clan, that's
Yes,
why
yes,
you're
my,
not issuing NOC?
yes, my lord.
That is your case.
That is the discrimination, my lord, that has been
What
done.
is the criteria for issuing NOC? Any guidelines?
Guideline is there, 1988 guideline is there, my lord.
So what is that? What is your case?
My case is, my lord, my case is that, my lord, this is my private land, my lord. I have been in occupation of this private land. And in the year 2005, my lord, I have constructed Kacha house, my lord.
This is not Kacha house, this is RCC house.
Yes, my lord. This is the final house, my lord, RCC house I have constructed, my lord. Prior to that, my lord, I have constructed house twice, my lord.
You're annexing the RCC building and you're saying I've constructed Kacha house.
My lord, earlier, in the year 2005, my lord, I have constructed Kacha house, my lord. That photo I have not annexed, my lord. This is the final, my lord, house I have constructed, my lord, that has been annexed.
Tell us, what is the criteria for issuing the NOC and what are the guidelines? And which of these guidelines have been flouted by the village authorities?
Now, my lord.
And secondly, whether the village authorities are a party in this petition?
Yes, my lord. I have
Who are
made
they?
a party, my lord.
Respondent number?
3 and 4, my lord.
3 and 4?
Yes, my lord.
So at this stage, let notice go.
Yes, my
What
lord.
to do?
Yes, my lord. Not
Let them also say why they're issuing their.
Yes, my
guidelines. Heard, Mr.
Lordship, Lordship,
Yes.
yes, Lordship. Lordship, first of all, Lordship, for direction of NOC to the villagers, he could not have come in the red, Lordship. Because, Lordship, LPC is issued to the private, this is really a question of fact, Lordship, this is. LPC is issued to the private properties, private lands, Lordship. If this is his private land, why he is not getting the NOC, Lordship?
That is exactly
This
issue, my
guy-
lord, because, my lord, as I have submitted, my lord, I belong from other clan, my lord. My lord, may kindly see, my lord, the NOC issued by the village authority, my lord. I have annexed all those documents, my lord. My lord, may kindly come to page number 22, my lord.
What is page 19?
19, page 19, my lord. My lord, page 19 is a letter, my lord. Recommendation letter for approval of allotment of land to the school, government high secondary school, Likabali, my lord.
Yes, by the deputy commissioner to the director of land management.
Yes, my lord. And my lord.
So what has it got to do with your case?
His home is near this school area, Lordship.
Correct, my lord.
This-
Correct, my lord. My lord, may come to just turn to page, next page, my lord. Page number 20, my lord.
20?
Yes, my lord.
Yes.
My lord, may see, kindly see the map, my lord. On the left side, my lord, I have marked, star mark, my lord.
Yes.
Star, my lord.
Star mark.
My lord, this, my lord, this line is the boundary of the school, my lord. And the star mark one is my private plot, my lord. Which
And what is that
out-
building
Which is outside the
line?
line, my lord. And I have built my building here only, my lord.
But how do we know that?
That, my lord,
This is disputed also.
How do we know that?
that,
Diagram is made by whom? It was made by the deputy commissioner's office.
yes, the
But it does not, does it say that this is your land?
My lord,
Your name is there.
no, my lord, it's-
Then
in the entire, my lord, this map, my lord, nobody's name has been given.
that is why if you just put a star mark, can we just say that
My
it
lord,
is outside
there-
or inside or like that?
Therefore, my lord, I have prepared a sketch map, my lord. When in the,
Everyone can prepare sketch map,
that, my lord,
but will it be accepted?
that, my lord, they can dispute, my lord.
You will,
So,
you will make the sketch map which is according to you, which will suit your purpose.
that is, therefore, my lord, notice may be issued, let them come with the affidavit and say that.
But see, NOC is to be issued by the village authorities, isn't it?
Yes, how can this lordship, court can direct this village authority to issue the NOC lordship? It's within the private properties only they issue NOC to each other, who are boundary to each other.
What the government advocate is saying that this is a dispute of purely between the private parties.
Yes.
So where will writ
No,
petition
no,
lie?
How come this?
Village
lordship, this
authorities are also, my lord, a part of the judiciary, my lord.
No, lordship.
No,
It
see,
it is purely.
you show me a provision that NOC is to be issued by the head Gawbura under these provisions.
That, my lord, then, my lord, this matter may be, this is taken up tomorrow, my lord. I will come with the notification, my lord.
You should have in the first place incorporated that in your writ petition. These are the guidelines framed by the government wherein head Gawbura will issue no objection certificate, which will be again submitted to the authority in the land management who will consider allotting of land, something like that.
In fact, my lord, that is not disputed. Since our AG is here, my lord, we can have the clarification on his side also, my lord. Because, my lord, these are the issues, my lord, which is not disputed, my lord. Therefore, we can have the help of the AG, my lord, regarding this issue, because it is the authority, my lord, village authority who issues the NOC, my lord.
No, you should help yourself
That is true, my lord.
by incorporating all the materials.
Then, my lord, let me.
Supposing you invite somebody for dinner, you will only serve rice and tell him that you bring curry also. I'll invite you for dinner. I'll prepare the rice only. You bring curry, you bring all this, and we'll have dinner. You have filed a writ petition with without those ingredients, and you want now somebody has to provide you the ingredients. You have to make out a case. It's issuing notice and all that is not for a mere asking.
My lord, if they are disputing, let them dispute, my lord. We'll have the charge for this filing the rejournal also, my lord.
Tomorrow is too short a time. We'll have it on Monday if you want to. Let it be listed again on Monday.
Then,
List again on Monday as paid for by the council for the petition. You bring those guidelines, everything, and you
Yes,
convene
ma'am.
the court.
Yes,
then
ma'am.
You'll get a notice.
yes, ma'am.
Okay.
Obliged, ma'am.
Yes, Mr.
Private
Picha.
respondent has to file their affidavit, my lord. Actually, this matter should be in order column, my lord.
Not yet. Affidavit not yet filed.
Yes, by the private respondent number 5.
What is the matter regarding?
Actually, my lord, there is a land dispute between the petitioner and the private respondent. Now,
So
he-
whether writ court can look into it?
My lord, I am challenging the decision of the extra assistant commissioner, my lord. Well, I am claiming that that the EAC does not have the authority for demarcation of boundary, my lord. It is the district land revenue settlement officer, my lord.
So number 5 is the person against whom you have this.
Yes, my lord.
And who is appearing for number 5?
Number 5,
Any
my lord.
notice is complete?
Yes, my lord. In the court is
Who's the counsel?
T. Bayor, T. Kumar, P. K. Gore.
So what is to be done then?
It may be listed after 3 weeks, my lord.
Although Mr. B. Picha, please write down, Mr. B. Picha, learned counsel for the petitioner, and Miss J. Ate, learned
For 3 and 4.
government advocate, senior government advocate, additional senior government advocate appears for the respondent numbers. You also there?
Yes, my lord, I'm for 1 and 2.
This appears for respondent numbers 3 and 4, and Mr. D. Kamduk, learned standing counsel, land management for respondent numbers 1 and 2. The respondent number 5 is not represented today. It is also seen that respondent number 5 has not filed counter affidavit. Stop. For ends of justice, further 2 weeks' time is granted to respondent number 5 to file counter affidavit, list again after 2 weeks.
Obliged, my lord. Yes. This writ petition is, my lord, we are claiming rent from the authorities concerned. my lord. Rent compulsory.
The rent.
Rent, yes, my lord.
Okay.
Now, my lord, the facts of the case, my lord.
Who's for the other side? Parties are ready. All the parties are ready.
Yes, my lord.
And yes.
Yes, my lord. Now, what happened, my lord, the Indian Army were in occupation of our land, my lord. So, my lord, we started submitting representation before the authority concerned and the Indian Army, my lord. So, my lord, page 43, my lord. First, we made the representation on page 42, my lord, on 11/8/2010, my lord.
How many petitioners are there?
We are 3, my lord. We are representing our family, my lord.
Sorry?
We are 3, my lord, here.
Three.
Petitioner 3, my lord. We are representing our family members, my lord.
Family members.
Yes, my lord.
So land belongs to not only the petitioners, but to the families also.
Yes, my lord.
Now, the area of the land, has it been
Yes, my lord. There has been judgment, my lord. Let me come to the facts, my lord. It will clear everything, my lord. Now, what happened, my lord? We submitted representation before the Commander 190 Mounted Brigade on 11/8/2010, my lord.
Yes.
For payment of adequate compensation, my lord. Again, on 16 August 2011, again we have submitted our representation before the Commander 190 Mounted Brigade, my lord, for acquisition of our land, my lord. Sorry, my lord, sorry. 16 August 2011 is the letter written by the Deputy Commissioner to the Commander Mountain Brigade.
No, the first representation at page 42, this is for what?
This is for acquisition of our land, my lord. For amicable settlement, because they were in our in occupation of our land, my lord.
Land measuring about 3 acres, it says.
My lord, we were not aware of the actual area of land. It will come in later part, my lord. Here we have written, my lord, 3 acres, but in the later part it came to know that the land is in occupation of the Indian Army is 481 acres, my lord.
481
acres, my lord. We will come to it, my lord. I will come to it.
Acres?
Yes.
That much?
Yes, my lord. Then subsequently, my
So
lord,
where is 3 acres and where is 400?
my lord, because we are village, we cannot measure the area, my lord. We don't have any tools to measure the area, my lord. It was by the district administration, my lord. Later it came to know. Even the Indian Army, they are, my lord, admitting that 202 acres were in their possession, my lord.
Okay, now this is the first representation?
Yes, my lord. Now,
Then?
my lord, on non-consideration, we have submitted representation before the Deputy Commissioner. Now, Deputy Commissioner write to the Commander 190 Brigade on 16 August 2011. That is page
43, my lord, the type copy would be page 44, my lord. No, basing on date, my lord, joint survey was carried out, my lord. Page 46, my lord. On 18 and 19 June 2012, my lord, first paragraph, joint survey of, my lord, 10 August 2012, my lord. Page 46, my lord. Joint survey of land acquisition Lunglo GG has carried out from 18 to 19 June 2012, and a total of 481.41 acres of land was surveyed. Map of the surveyed land duly signed by the landowners, GB and Circle Officer KP is enclosed here for obtaining signatures of your office administration staff. So it's on. This was written by the Lieutenant Colonel Quartermaster for Commanding Officer, my lord, to the Land Management Circle Officer. Subsequently, my lord, page 47, on 13 December 2013, my lord. Again, the officer quartermaster, my lord, for CO, my lord, has written letter to the DA4, my lord, Tawang, my lord.
This is for what?
District Forest Officer, not District Divisional Forest Officer Tawang, my lord.
Yes, for what purpose?
For seeking NOC, my lord. May I, my lord, serial number 2, para 2, my lord. The brief details of LGG land case is as under. A total of 481 acres of land is required to be acquired at LGG, my lord. The land has been surveyed and NOC obtained from landowners and forward to Circle Officer Kitpi and then to DC Office Tawang on 10 August 2012. DC Tawang forwarded the case to DA4 Tawang for forest clearance. It was then recommended by Forest Department to do the ground raise of the area to assess whether the rare species of so and so are avid in area or not. Thereafter, so and so. So, my lord, here the NOC was sought from the DA4 by the Indian Army for an area measuring 481.41 acres. Now, my lord, survey was conducted by the district administration, my lord. Page 48, my lord. Page 48, my lord. A committee was formed and the report. This is the report, my lord. In pursuance of the government notification dated so Itanagar dated so and so, the physical verification of entire project of LGG so and so 481.43 acres have been carried out by the members of the committee on so and so to verify the extent of the community land, individual land, and forest area to be acquired for so and so. Now the total area comes to 481 acres. The classification, my lord, is that unclassed forest state area 160.47 acres. Community land area so and so. Private land with individual customary so and so. Forest cover 160.5 acres. Non-forest cover 320.93 acres. Total area 481.43 acres. Now, despite this, my lord, report and this survey conducted by the authority concerned, my lord, along with the Indian Army, my lord, no action was taken, my lord. Against that, we have filed a writ petition, my lord. Page 49, my lord. WPC 390 of 2015, my lord.
So, physical verification was done on which date?
This physical verification, my lord, was carried on 14/6/2014.
Now, what was who had, on whose direction was this conducted? Physical verification.
My lord. My lord.
On whose direction? First of all, it was joint survey.
It was only,
Then
my lord,
NOC was sought from the forest.
Yes, my lord.
Then this
And
physical
this is-
verification again?
Again, on the, my lord, this government notification dated 14/3/2011. It is not with me, my lord. My lord, may I read? In pursuance of government notification number LR so and so, dated Itanagar, the 14/11/2011. my lord. The physical verification of entire project area of so and so have been carried out by the
members of the committee on so and so to verify the extent of the community land, individual land, and forest area to be acquired for the above said project. The findings of the committee are as under. For LGG 481.43 acres. The members were from the DFO, DLRSO, circle officer, and the EAC, in charge deputy commissioner.
So forest was there, then for the deputy commissioner was there again.
Yes, ma'am.
DLRSO means
District Land Revenue Settlement Officer. Ma'am.
okay.
Circle officer was here, ma'am.
Hmm.
And the EAC, ma'am, who is the in charge deputy commissioner. Ma'am.
Okay, so thereafter you filed writ petition.
Writ petition before this honorable court, ma'am.
2015.
Yes, ma'am. 390 of 2015, ma'am. On the relevant part, I will take to your lordship, ma'am. Pleadings were exchanged, my lord. Now, page 54, my lord.
Yes.
Our claim in the writ petition was that, my lord, since 1980, last paragraph, my lord, since 1980, the Indian Army has been in occupation of the land. Petitioner has submitted representation that so and so to the commander 190 brigade, so and so, my lord. Now, my lord, page 55. Last paragraph, my lord. Admittedly, the army authorities are in occupation of the land in question since 1980, my lord. And no rent in respect of the land in question has been paid to the petitioners. No process for land acquisition has been started by the respondent authorities. It appears from the pleadings that petitioners are not ready to lease out the land either in short-term or long-term basis, my lord. Now, in view of the circumstances, the respondent authorities may acquire the land as per so and so. That is New Land Acquisition Act, and if they deem it fit, or they shall have to vacate the land in occupation on payment of reasonable compensation for their occupation since 1980. My lord. Now, issue of 1980, my lord, since occupation has attained finality, my lord, by this judgment, my lord. Now, my lord, what happened on page 57, my lord, the Ministry of Defence has also given, my lord, the in principle approval for acquisition of 481.41 acres of land, my lord. Page 57 or type copy would be at page 58, my lord. And there has been some communication between the Indian Army, my lord. But that would be page 60, my lord. May I read, my lord, page 60. In principle approval of Honorable Raksha Mantri for acquisition of 481.41 acres of commercial land at general area Lungro ground so and so of Bondir Blaze under Kitpi so and so for operational deployment of army has been accorded by so and so. So, my lord, the in principle approval was given on 16 March 2017. What we gather from para 1. Now, my lord, the defense estate officer in page 61, my lord, on 26 May 2017, my lord, has also written to the deputy commissioner, my lord, for forwarding of revised estimate cost of land, my lord. May I read, my lord?
Just a minute. Just a minute. This 28 page 60.
60, yes.
60 is prepared by whom?
This is the communication between the, my lord, Indian Army, my lord.
And Indian Army and whom?
By Deputy Director, my lord, Land Northeast, my lord, John. This is also from Ministry of Defence to is headquarter Eastern Command Land Pin so and so. All in all, my lord, this page for this annexure 8 series, my lord, page 57 to 60, my lord. What I want to show, my lord, that this in principle approval was also given for acquisition of land of 481.41 acres, my lord.
Page 61.
Yes, my lord. Now the Defence Estate Officer Tejpur, my lord, has also written to the Deputy Commissioner on 26 May 2017, my lord, referring to the in principle approval. It is para 2, my lord. It is intimated that this office has received in principle approval of Raksha Mantri for acquisition of 481.41 acres of community land at so and so LGG of Bondir Blaze so and so for operational deployment of army. A photocopy of the same is forwarded here with for your perusal, please. It is observed that the whole land has been categorized as developed cultivable land, whereas almost 60% of the land is covered by ridges. Even on flat surface, there is very thin layer of soil soil. With reference, you are requested to provide revised cost of 481.41 acres of land with due consideration of appropriate class of land as per ground reality.
Revised cost.
Revised cost. It appears, my lord, there was a.
There was
one-
already a calculation.
Yes, my lord. No, it appears, my lord, the cost was prepared. The valuation was prepared, my lord.
Where is that valuation?
It is not with me, my lord. But it is in interdepartmental, my lord, communication, my lord. It was never provided to us, my lord. The type copy
So anyway, there was some assessment or
was,
some
yes, valuation was done.
estimate was made, valuation was done.
Yes, sir.
So this defense estate officer again writes that you just have a look at it again,
Yes, my lord.
make a revised cost and furnish it to us.
Yes.
Then
My lord, page 64, my lord.
64.
Now, in southern U-turn, my lord, defense estate officer says, my lord, they are in required of only 202.56 acres, my lord. My lord, may see, my lord, may I read, my lord. Para 3, my lord.
Yes.
In this connection, you are therefore requested to forward the following for further process of land acquisition at LGG at earliest. Cost of 202.56 acres land as per ground reality considering the appropriate class of land. NOC shows willingness from land owners to sell their land to the army on payment of compensation. NOC of district administration, so and so on. Now they say, my lord, they are in required of 202.56 acres. Well, page 65 to 66 is the type copy, my lord.
Yes.
Subsequently, my lord, adhering to the judgment passed by this honorable court, my lord, they started land acquisition process, my lord. Page 67 is the, my lord, preliminary notification, my lord. Type copy would start from page 69, my lord. On 5 January 2021, my lord. 5 January 2021, my lord, they issued a preliminary notification, my lord. May I read, my lord?
Yes.
The last third paragraph, the Deputy Commissioner Tawang District Judicial Service is appointed as administrator for purpose of rehabilitation and settlement of the affected families. Therefore, it is notified that for the above said project in the Lungro GG grazing ground, Bomdir so and so, Block so Tawang, a piece of land measuring 202.56 acres of standard measurement whose detailed description is below is under acquisition. Last, my lord, page 70, my lord, down below. This notification is made under the provision of section 11, subsection 1 of the right to fair compensation, so and so on. Section 11 says, my lord, for preliminary notification, my lord.
Where is that?
My lord, page 70, my lord. 70, the last paragraph. My lord. This notification is made under the provision of section 11. My lord, this date would be, my lord, very, my lord, essential, my lord. 5th January 2021. This is the notification.
Yes.
Then, my lord, what happened, my lord? They also prepared the estimate, my lord, page 72 is the estimation, my lord.
Yes.
So, estimate, my lord, we were given, my lord, our value, our property was assessed for 37 crore, 10 lakhs, 16,180, my lord. Including the departmental charges, my lord, it was 37 crore, 48 lakhs, 27,989, my lord. Page 72, my lord. In lieu of this land acquisition process, my lord, 20% of the compensation was paid, my lord. Page 73, my lord.
What is the figure? 374?
Total compensation, my lord.
827989.
Yes, my lord.
Out of which how much was paid?
Firstly paid, my lord, 16 crore, my lord.
Which amounts to how much? 16 crores was paid.
Yes, my lord. Initially, as a first installment.
When was it paid?
16 April 2021, my lord. It was deposited in the account of the Deputy Commissioner.
Rupees, how much? 16 crores.
16 crore, 68 lakhs, 71,004. 4 rupees.
Yes.
Yes, my lord.
Then, my lord,
Okay, this is from page 73.
yes, my lord, page
All right.
73.
Then,
My lord, under section 19, my lord, they issued a notification for possession of the land, my lord. Page 74, my lord. This is the notification, my lord. It was issued on, my lord, 27 April 2021, my lord. In the Gazette, it was issued on 7 May 2021.
Yes.
Now, my lord, on 11th May 2021, they passed an award, my lord. Deputy Commissioner passed an award, page 76, my lord.
Page
76, my lord. This is the award, my lord.
Okay, yes.
Yes, ma'am. This is the award. We are paid the compensation, my lord.
Remaining balance.
Yes, my lord. This is the award, my lord. Remaining balance was later on paid, my lord. Entire amount was paid, my lord.
This is the entire
Yes, my lord.
award.
It contains entire amount, yes.
What is the date? 17 May?
11th May 2021.
11 May.
Yes, ma'am.
What is the figure? Total amount?
Total amount is not given, my lord.
Serial number 15?
Yes, my lord. Serial number 15. Yes, my lord.
This tallies with the earlier amount?
Yes, my lord.
So. Yes.
May I, my lord?
Yes.
Page 77. On, my lord, learning that we were not paid, my lord, rent, my lord, for the period of occupation from 1980 till 2021, we submitted a representation, my lord.
1980.
Till 2021, my lord. The date of notification.
21.
Yes, 2021. my lord.
21 is the notification date for
Preliminary notification, my lord.
preliminary. Okay.
That is, my lord, 5 January 2021, my lord. Page 69, my lord. It's a type copy, my lord.
So this is where the issue lies.
Yes, ma'am.
Regarding rent.
Yes.
Then this page 77 is what representation.
The representation before the authorities, my lord. For payment of rent, my lord. Now, my lord,
Yes.
we have some knowledge, my lord. Now, earlier, my lord, the district administration, my lord, had initiated for payment of rent for occupation of period from 1980 till that, my lord.
Yes.
Now, it was never materialized, my lord. Page 80, my lord.
When you say 1980, which part of 1980?
We say 1980 because 1980, my lord,
From January.
we can take from any month, my lord, 1980, my lord, because at that point of time, my lord, we were unaware of this, my lord, month and all that, my lord. But we
Okay.
can say since 1980, my lord.
Prior to 1980, it was not in occupation.
Yes, my lord. Since till 1979, the land was in our occupation, my lord. From 1980, my lord, the Indian Army came in, my lord, into being, my lord, and
Okay.
they took possession of our land, my lord.
Yes, now you're showing me what, Annexure 70?
Yes, my lord. Page
Page
80, my lord.
Page 80. What is this?
This is the, my lord, rent, my lord, estimate prepared by the district administration, my lord, which was not materialized, my lord. But it appears from this report, my lord, they had initiated some process, my lord. Serial number 1 pertains to us, my lord. Private land, my lord, Glongro, LGG, under Kitpi Circle, area measuring so and so, lease area, rate 3 rupees, my lord, per square meter. Lease period 1980 to 2007, my lord. Amounting so and so.
Okay, now serial number 1 is private land. Number 2 is community land.
This serial number two does not pertain to us, my lord.
You are concerned with only serial number one.
Yes, my lord. So some initiation was initiated, my lord.
Hmm.
Some process was initiated, but it was not completed, my lord.
Hmm. Lease rate is rupees 3 per square meter.
Yes, my lord. Lease period 1980 to 2007, my lord.
But there's a long span of
Yes.
28 years.
My lord.
Should the amount remain the same for 28 years?
Well, that would be calculated by the deputy commissioner, my lord. We are not claiming this amount, my lord. We are only for a direction upon the district administration. To
This is just to show that there was some initiation.
exercise. Some exercise was carried out, but it was not materialized.
And what is the rent?
Well,
any rent thing you follow in the state of Arunachal Pradesh?
To my knowledge, my lord, from occupation till 2010, my lord, the rate is 3 rupees per square meter, my lord.
No, I'm not on that. I'm
Yes.
saying, is there any act or rules
My lord,
regarding governing the rent?
That is, my lord, to my knowledge, my lord, 2000 till 2010, 3 rupees is there, my lord. After 2010, 10 rupees is there, my lord.
How? On what basis? I'm not on the amount.
My lord.
10 rupees, 20 rupees, not like that.
No.
I'm saying, is there an act? Like in other places, we have the Urban Rent Control Act,
My lord, my lord. There is no rent control act.
Rent
In our
Control Act or something like that, wherein
not-
there is a stipulation of how it is to be calculated. You don't have that.
My lord, we do not have that, my
You
lord.
don't have.
But for the area, my lord, yes,
So,
it is there, my lord.
on what basis is the rent calculated then?
It is calculated by the deputy commissioner. To my, what I have been informed, there is a notification, my lord, or circular something, my lord. Till 2010, my lord, the area per square meter is, my lord, is taken as 3 rupees value, my lord. And after 2010, it has been taken as 2010, my lord. Even, my lord, state has a notification of 2000, state notification for land management. My lord. There is a manual of 2022. It is also provided there, my lord. The land management will, my lord, inform, my lord, the council for the land. There is a notification, my lord, for the rate of rent, my lord. In the land manual, my lord, 2022, my lord. I can get it print, my lord, today, sir. I have that, my lord.
What thing?
That land manual, my lord.
Manual.
Yes, my lord. Land acquisition. The value is for purpose of valuation, my lord. There is a, my lord, notification, my lord, of 2022, my lord.
Now, if provision is there, it's well and good.
No,
Because basically the calculation has to be done by the authority concerned.
Yes, my lord. Authority concern only.
Now, question now is that whether you're entitled to that rent or not.
Yes, my lord. That
That
is the
much
question.
only is
Yes, yes. That
what
is
we
the
want to
question.
put.
Yes, my lord. So, my lord, what I am saying, my lord, by the judgment and order dated 2/3/2016, my lord, it has been, my lord, clarified and everything has attained finality. Page 49, my lord, is the judgment, my lord. And the relevant portion, my lord, is at page 55, my lord, where this honorable court has come to the conclusion that since 1980, the Indian Army is in occupation of our land, my lord. May I read again, my lord?
It's okay. We have read
My-
it.
Yes, my lord.
So now what is your case?
Now, my lord, I am seeking land, rent from the year 1980 till, my lord, 2021. Still notification, my lord. For that, my lord, I would like to place some judgment, my lord.
No, okay, just a minute. Initially, there was a survey. What was the area?
My lord,
481.41 acres of
my lord.
land.
Yes, my lord.
Then
Again-
this has now come down to 200 and
2 acres. Yes, my lord. May I take your lordship to affidavit filed by the, my lord, the Union of India, my lord? That would be relevant, my lord.
just a minute, just a minute. Yes, this 4841, no, 481.421 acres has been restricted now to
202.
202.56 acres.
Yes, my lord.
And for which the acquisition proceeding was initiated and amount fully paid
Yes,
by now.
yes, my lord.
But your case is that since the rent has not been paid
Yes, my lord.
prior to the issuance of this notification for possession.
Yes, my lord.
Possession was 27/4/2021 under section 19.
Yes, my lord.
So you are entitled to be paid rent from 1980 to 2021.
Yes, my lord.
And this fact has already been established. There's no dispute regarding this because in the earlier round of litigation,
My
the
lord.
court also had observed that
Yes.
since 1980, admittedly, your land was occupied.
Yes, my lord. And my lord, page 13, my lord.
Page 30,
Yes, my lord.
30.
1-3, my lord, of my writ
13.
petition. Yes, my lord. It is in paragraph 3, I have stated, my lord. The forefathers of the petitioner had used the land for cultivation purpose and later converted the same into grazing areas for their animals such as yak, so and so. And some parts of the land has been used for construction of their dwelling house. The petitioner since time immemorial have been using the land without any hindrance from any government. It is a matter of fact until 1979. The petitioners were enjoying the peaceful possession of land without any disturbance from anyone. However, in the year 1980, the Indian Army gradually started to enter into the land of the petitioner.
Now you show me the counter affidavit.
Yes, ma'am.
They have not denied.
My lord.
Is that what you want to say?
Yes, my lord. Affidavit filed by the respondent number 1, 2, and 3, my lord.
This is in paragraph. Which paragraph is that? Which you just read?
Paragraph 3, my lord.
3.
Yes, my lord.
You said 3 acres, so they say that petitioner says it's 3 acres. Now, how come he's saying 200 something or 400 something?
It is on the, my lord, we do not have any mechanism. We are the villagers, my lord. We do not have any mechanism to measure the area, my lord. We can roughly say, my lord, this much of area has been occupation, my lord. But on verification, it was found, my lord.
So you can also say that if you say that 3 acres of land is only required, then why did you acquire 200 and so acres of land?
My lord, that is why, my lord, may I take your lordship to affidavit of respondent number 1, 2, 3, my lord. Respondent number 1, 2, 3.
Yes. Which paragraph?
Paragraph, my lord, 10, my lord.
10.
Yes, my lord.
Yes.
My lord, may I read page 6, my lord?
Yes, read.
No, yes. Subject to the assessment so and so as to whether the entire land is to be acquired or otherwise. It has been clarified that such in principle approval and endorsement of land acquisition process from operational security, operational necessity angle with not covered under the extent of land required, which will be assessed by the D lands. Hence, the in principle approval of the MOD is merely an approval of necessity of land for processing the proposal for land acquisition. The IPA is not final sanction of the government for acquisition of land. The final sanction for acquisition of land is issued after actual area measuring by the identity agency, that is Indian Army, is computed by a board of officers. In order to assess the actual area under occupation in the present aforesaid High Court order, a joint survey was conducted comprising all concerned with immediate effect from 18 so and so to 10 so and so. It was a, my lord, almost 20 days, my lord, survey, my lord, to find out the actual quantum of land in occupation of army, my lord. After survey, it was found that only 563 acres of land was under the occupation of the army. This is their admission, my lord. The headquarters is so and so, dated so and so, directed the 4 corps to prepare board proceedings for acquisition of 200 so and so acres land only, which is the actual area under physical occupation of the army. So, my lord, we are ready to give away 481. We are ready. We are also acceptable to 202 acres, my lord. This is our submission, my lord. Because they are admitting, my lord. We do not want to make any dispute, my lord. We want only, my lord, compensation, my lord. Is it right, my lord? So 202 also we are acceptable, my lord. Again, in my lord, para 11 also, my lord. May I read, my lord?
Yes.
That with regard to statement made in para 11 of so and so, department begs to submit that the High Court directed so and so directed for either acquisition or vacation of land in occupation. In order to assess the actual area under occupation in present to aforesaid High Court order, a joint survey was conducted so and so to find out the actual quantum of land in occupation of Army. After survey, it was found that only 202.563 acres land was under the occupation of the Army. Accordingly, this office, that is respondent 3, by order so and so, that intimated the same to the local military authority at LGG with a request to apprise the Honorable Court regarding actual occupation land by the Army at LGG.
Okay, what is that to apprise the court? Any such information was given?
This is respondent number 3. Respondent number 3 is the defense state officer, my lord. This
So-
is their communication, my lord.
Is there any written anything, any communication in that regard?
My lord, para annex, they have said annex 3, my lord.
Of the counter affidavit?
Yes, my lord.
Correct, it's there.
My lord.
It may therefore be conveyed to the Honorable Court through CGC. The Army is an occupation of only 202.56 acres.
Yes, ma'am.
And not 481.79 acres. Yes.
So, my lord, we are acceptable for 202 acres also, my lord, without disputing the facts, my lord.
Is that all?
My lord. Now, my lord, I would like to make rely on some decisions.
Yes, what are those?
Yes, ma'am. My lord, 2004 for SSC. My lord, the RL Jain case. 2004 for SSC, page 79, my lord. Para 18, my lord.
What does it say?
Here the issue was that, my lord, the petitioner hearing has sought to, my lord, interest on the section 34 of 1894 Act, my lord, for occupation before notification, my lord. Now, the full bench of the Supreme Court was under consideration whether the interest can be given or not. Now, my lord, on interpretation, my lord, this the Honorable Apex Court in this decision in para 18, my lord, has stated that the petitioner would be entitled for rent, my lord, not interest, my lord. Section 34 and section 80. Section 34, my lord, section 80 is pari materia to section 34, my lord. Section 34 of 1894 Act, my lord, may I read?
It's parameter to section?
My lord, 84, my lord, section 34.
84 and 34?
Yes, 84.
84 of the 2013 Act.
Section 34 of 1894 Act and section 80.
80.
80 of 2013 Act.
Okay.
Are same. So issue was same, my lord.
Payment of interest.
Yes.
For having occupied the land before payment of compensation.
Before
So, if
notification. Yes, my lord.
Before occupation, if the compensation is not paid,
my lord, yes,
then interest has to be paid under
yes, my lord.
34.
From the date of possession, my lord. As
From
per
the-
section 34, it is from the date of possession, my lord.
From the date
Now,
of
it was interpreted here, my lord, from the, no, my lord, they will not get interest, but the rent, my lord.
Let us see, page 18, para 18.
Para 18, my lord, first, my lord, the score issue, my lord, before the Honorable Apex Court.
Where is that? For issue?
Score issue, page 84, my lord.
Paragraph?
Paragraph 1, my lord.
Hmm.
The appeal has been placed hearing before this larger bench, and the question in issue is whether in a case where possession is taken before the issuance of notification under section 4(1), which is pari materia to section 11. of Land Acquisition Act, the claimant is entitled to interest for such anterior period in accordance with section 34 of the said act, my lord. May I read section 34? my lord?
Just a minute. Section.
Eighteen 1894 Act, my lord.
Yes, read.
Yes, section 34, my lord.
Read.
Payment of interest, my lord.
Yes.
When the amount of such compensation is not paid or deposited on or before taking possession of the land, collectors shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it shall have been so paid or deposited. Provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date of which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the payment of compensation or part thereof which shall not be paid or deposited before the date of such expiry. So here, the possession was taken under consideration.
1980. So in your case, possession was done in
1980.
1980.
Yes, my lord. So para 18, my lord.
So you were initially you were into the rent. Now you're also into the interest.
Yes, my lord. Initially we were for compensation, my lord. So, my lord, for permanent acquisition they have paid, my lord. Now
No,
we are
compensation already paid.
yes, my lord.
Now rent is not paid.
Yes, my lord. Yes.
Now over and above the rent, you are saying interest also has to be paid.
No, my lord. Now here, my lord, the issue before the apex court, my lord, was whether the interest has to be paid. The court says no, the rent has to be paid, my lord. My lord, that's why, my lord, may please come to para 18, my lord, page 93, my lord, of the judgment, my lord. Here the claim was whether the interest has to be paid, my lord.
You're not claiming interest.
Yes, I'm not claiming interest, but
You're
this
claiming rent.
yes, my lord. This issue has been settled here, my lord, in this judgment, my lord. Now, para 18, my lord, page 93, my lord. May I
So,
read?
just a minute. You're reading section 80?
No, my lord.
Okay. So section 80
my lord, yes.
and section 34 are paramaterial.
Paramaterial, yes, my lord. Nothing has been changed, same.
Oh, let us see the judgment now of the apex
Yes,
court.
yes.
Page
Page 93, my lord.
93.
Yes, my lord.
Yes.
Para 18, my lord. May I read, my lord?
Yes.
In case where the landowner is dispossessed prior to the issuance of preliminary notification under section 4(1) of the Act of Government of the Act, the government merely takes possession of the land, but the title thereof continues to vest with the landowner. It is fully open for the landowner to recover the possession of his land by taking appropriate legal proceedings. He is therefore only entitled to get rent or damages for use and occupation of the period of the government retains possession of the property. Where possession is taken prior to the issuance of preliminary notification, in our opinion, it will be just and equitable that the collector may also determine the rent or damages for the use of the property to which the landowner is entitled while determining the compensation amount payable to the landowner for acquisition of property. The provision of section 48 Act lend support to such a course of action. For delayed payment of such amount, appropriate interest at the prevailing bank rate may be awarded. By this judgment, I can also be awarded with the interest, my lord. This is the judgment of full bench, my lord.
Now, under the 2013 Act,
my lord,
what is the provision which is paramaterial to section 18 of the LA Act?
18, my lord.
18 reference.
Reference, my lord. My lord,
You have not preferred any references.
My lord, yes, my lord. My lord, your lordship has passed one judgment, my lord. My lord, this writ would be live, my lord, by the division bench of this honorable court, my lord, authored by your lordship, my lord. Writ is maintainable, my lord. And my lord, reference, my lord.
No, but you could have filed a reference also at the relevant time. That amount which is assessed by the collector is acceptable to the parties.
My lord.
But the rent, my lord.
The rate,
Rent.
not rent, rate, the rate of the land.
Rate of the land, yes, my lord. We
It
have
was
accepted.
acceptable.
Yes, my lord.
It was at what rate? Per square feet or something like that?
That the valuation, my lord.
Yes, the value of the land.
Value of the land was taken as 155 square per meter as a grazing land, my lord. It was taken on the custody.
155 rupees
155 rupees per square meter.
per square meter.
Yes, my lord. My lord, there is a state notification, my lord, itself. My lord, as per the notification of the state, my lord, grazing land.
This is in a rural area, that's why.
Yes, yes, yes.
Rural area.
Yes, my lord. My lord, page 72 of the writ petition, my lord, the valuation, my lord, category of land, grazing land, my lord, page 72. This is the valuation, my lord, estimate of cost of land.
$155
Yes,
per
my lord.
square
Serial
meter.
number- serial number 4, my lord, category of land, grazing land, my lord.
It's a grazing land,
Yes,
so it's a far-flung area, that's why.
Yes,
probably.
ma'am. Rate per
Anyway,
square meter, 155.
The matter is over.
Yes, ma'am.
Since, see, what I was saying is that at the relevant time, you could have raised the issue of rent also. Because as per the judgment which you just referred to,
my lord,
the apex court also said that rent can be claimed.
Yes, my lord.
So at the relevant time, you could have said, okay, we accept whatever you have assessed, but what about our rent?
Yes,
Give
ma'am.
us the
Yes,
rent.
that is why, my lord, we have submitted representation, my lord.
You could have done at the same time, but
My lord,
anyway.
now, my lord,
Uh,
we are believers, my lord.
hmm.
We do not know the intricacies of law, my lord. My lord, I would take your lordship to 2011 5 SSC.
But they must have had the assistance of learned counsels.
No, my lord.
The first
We-
writ petition
we-
was filed in the 2016.
My lord,
Award was made in 2021 only.
we are only here to place the, my lord, the facts of the petitioners, my lord. We cannot pursue the matter before the, my lord, district collector, my lord.
Yes, 2011.
Yes, 11 5 SSC.
This is regarding.
This is regarding, my lord, I would say, my lord, the court cannot expect a rustic villager to be aware of various laws, my lord.
Paragraph.
Paragraph 21 and 24, my lord. May I read, my lord?
Yeah, please read.
21, my lord, paragraph 21. Therefore, while examining the landowner's challenge to the acquisition of land in a petition filed under Article 226 of the Constitution, the High Court should not adopt a pedantic approach, as has been done in the present case, and decided the matter keeping in view the constitutional goals of social and economic justice, and the fact that even though the right to property is no longer a fundamental right, the same continues to be an important constitutional right, and in terms of Article 30A, no person can be deprived of his property except by authority of law. Now, para 24, my lord. We may advert to the ancillary question whether the High Court was justified in non-suiting the appellants on the ground that they failed to discharge the primary burden of proving that the state government had invoked section so and so without application of mind to the relevant consideration. In this context, it is apposite to observe that while dealing with challenge to the acquisition of land belonging to those who suffer from handicaps of poverty, illiteracy, and ignorance, and do not have the resources to assess the material relied upon by the functionaries of the state and its agency for forming an opinion or recording a satisfaction that the agency provides contained in section so and so should be restored, and to or the inquiry emphasized under section 5A should be dispensed with. The High Court should not literally apply the abstract rules of the burden of proof and cite in the Evidence Act. It is too much to expect from a rustic villagers who are not conversant with the intricacies of law and functioning of the judicial system in our country to first obtain relevant information and recourse from the state authorities concerned and then present skillfully drafted petition for enforcement of their legal and constitutional rights. Now, my lord, 2008 to SSC. Case 717.
This is regarding.
Regarding, my lord, order not challenge attains finality, my lord.
Okay, that earlier petition.
Yes, my lord. Yes, my lord.
Okay.
That has attained finality.
Paragraph.
Paragraph 13. my lord.
1-3.
1-3. Should I read? My lord?
Read.
My lord, having heard, para 13, having heard learned counsel for the parties, in our opinion, the appeal deserves to be allowed. So far as termination of services of the workman is concerned, the question was decided in his favor in earlier proceeding which had become final, and it is not open to the corporation to argue that point. It has rightly been stated on behalf of the corporation that order holding termination of service of the workman being illegal and contrary to law had reached finality. Now, my lord,
You're reading from which?
para 13, my lord.
30 or 13?
1-3, my lord. 717, para 13, my lord. 1-3.
Okay, yes.
No, my lord, I would like to rely on the judgment of our honorable court, my lord. In the same issue, my lord. This honorable court, my lord. Here also, my lord, the same issue, my lord. Para 2, my lord. In this petition under 226 of the Constitution of India, the petition namely so and so have prayed for issuing the direction to the respondent authorities to disburse the land compensation rent amount for the land in question for the period from 1962 till date, my lord. Now, para 6, my lord. Para 6, my lord, next page, page 6 would be relevant, my lord. Page 6, my lord. Page
6.
Yes, my lord. Page 6 of the judgment, my lord.
Yes.
Internal page, my lord. And 13 line below, my lord. 13 line.
From below.
Yes, my lord. No, from the top, my lord. From the top, 13. 81A, 81A, sir. My lord has seen.
Yes.
Mr. Mazumdar also submits that the petitioner have also prepared one writ petition being so and so where this court has pleased to issue direction for paying of compensation to the landowners after taking a decision regarding the area of land being occupied by the so and so while disposing of land. It appears that the compensation to be paid for acquiring land would not include any rent that may be entitled to the so and so. However, liberty was granted to the petitioner to file fresh application. Accordingly, the petitioner has approached this honorable court by filing the present petition claiming rent compensation for occupation of land by a so and so. And therefore, Mazumdar submits that respondent authorities may be directed to ascertain the rent from 1962 onwards till today in consultation of district land so and so and other others to pay the same, my lord. Now, my lord, para 18, my lord, of the judgment, my lord. Under the facts and circumstances discussed here and above, this court is inclined to dispose of the writ petition with following directions. The respondent number 7 shall conduct a joint survey with the ITBP official in Manigal so and so in presence of the petitioners to ascertain the actual area of land being occupied presently by the ITBP and earlier by the AR, and further to ascertain since the land of the petitioner were being occupied in so and so. Therefore, to ascertain the rent compensation which petitioners are entitled to for the land being occupied by the Aswal AR so and so. To exercise to carry out so and so 6 months from the date of receipt of the certified copy of this judgment and order dated so and so. Para 20, my lord, the writ petition was allowed. Now, my lord, there is another judgment. My lord.
This also has become final.
Yes, rent.
This is final. Any appeal against this?
No.
No appeal.
No appeal.
This is not your case.
This is, my lord, for rent, my lord, for direction, my lord.
I understand. This was rent.
Yes, ma'am.
What has happened to this order? It has not been challenged.
Not challenged, ma'am.
Okay.
Now, my lord, this is also of our High Court, my lord. This is also occupation by the Indian Oil, my lord. Here, my lord, I would like to rely on paragraph 9, my lord.
9.
Yes, my lord. From the internal page, my lord, 5.
Okay.
From the aforesaid pleadings and submissions of the parties, it is clear that before issuance of preliminary notification under so and so, the possession of land in question was taken over in exercise of power under whose formulated under Assam land so and so. Then, my lord, para 12, my lord. Mr. So-and-so, learned MBS to submit that the Honorable Apex Court in so-and-so RL Jain, which I have relied, my lord, held in so-and-so, my lord, disposes prior to notification. The position of the land, but the title.
This is what you read,
Yes, my lord.
2004,
Yes,
volume 4.
Yes, my lord. Now, my lord, 14, my lord. In view of the uncontroverted fact that possession was taken over prior to the issuance of preliminary notice under section 4(1) of the Land Acquisition Act 1894, the petitioners are entitled for rent or damages for use of the property by the ONGC in as much as section 23 of the Act 1894 makes provision for additional compensation, and 48(3) makes it clear that compensation on withdrawal of acquisition proceeding need to be determined as per part 3 so and so. Now, my lord, para 16, my lord. In the present case, possession of the land having taken prior to the publication of the section 40 so and so, the award is not available. The only available terminal is the date of possession. Therefore, in considered opinion of this court, based on the principles law cited by the learned amicus, the appellants were entitled to the additional compensation of so and so for the period of so and so, and the same has already been circulated by the so and so. So, my lord, by this, my lord, the direction was given to the authority concerned to pay compensation.
See, the provision here was Assam Land Acquisition Act 1894.
Yes, my lord. But the 1894 was also, my lord, because the issue was the possession was taken prior to preliminary notification, my lord. Only issue, my lord.
No, the Land Acquisition Act is of 1894.
Yes, my lord.
Assam also has the same year.
No, my lord. Yes, my lord. It seems, yes, my lord. Assam Land Acquisition Act 1894, my lord, is there.
They have a separate act?
We do not have any separate act, my lord.
No, Assam.
Assam, yes, my lord.
See, Assam.
Yes, my lord. Yes, my lord, first page, my lord, of the judgment, my lord. In the head note, my lord. Assam Land Acquisition Act, Assam Land Acquisition Act 1894, my lord. Now, my lord, this last judgment, my lord. This is also of our High Court, my lord. Para 2, my lord.
Para 2?
Yes, my lord. By this petition under Article 226 of the Constitution of India, the petitioner has prayed for an order for payment of rental compensation to her for occupation of land by the security forces for the period from 1996 to 11/6/2018. Para 3, my lord, the grievance of the petitioner in this petition is that she is the absolute and legal owner of a plot of land covered under land so and so and so. Although the said land was occupied by the security forces in 1996, the acquisition proceeding was initiated only on so and so by publishing a preliminary notification. My lord, will we continue at 2, my lord? It is, yes. This is the last judgment which I will be citing, my lord. This one is relevant, my lord, for me.
You tell me the relevant paragraphs.
My lord, para 2, 3, 7, 10, and 11.
All right. So we'll resume at 2.
My lord. Yeah, my lord.
You have completed?
Not completed, my lord.
Not completed?
Not completed.
Okay, what else?
My lord. This judgment, my lord. This is something relevant to me, my lord.
Which one?
This,
the last one?
Yeah, last one, yes, ma'am. Lalnun tribe. Yes.
You're having difficulty in pronouncing it. I'm also having difficulty in pronouncing the local name. This is Lalnun Thari. Yes.
Yes, my lord. Para 2, my lord. By this petition under 226 of the Constitution of India, the petition has prayed for an order for payment of rental compensation to her for occupation of land by the security forces for the period from 1996 to 2018. Now, my lord, para 3, my lord. The grievance of the petition is that she is the absolute land owner of plot land covered under the land settlement so and so located at so and so so and so. Although the land was occupied by the security forces in the year 1992, the acquisition proceeding was initiated only on 11/6 by publishing a preliminary notification under section 11 of the right to so and so. It is the case of the petition that in spite of occupation of a land by the security forces under the Ministry of Defense, Government of India since 1996, she has not been paid any rent by the respondent till date. Now, my lord, para 4, my lord. Para 4, my lord, the internal page 4, my lord. Next page, my lord. Para 4.
Yes.
Yes, my lord. My lord, the 5th line from below, my lord. Mr. So and so. The facts, my lord. Facts is related to my case, my lord. Mr. So and so further submits that although the land of the petitioner was acquired on a permanent basis by award number so and so of 2019, the petitioner has never been paid any rent or compensation, and she has been deprived of her peaceful possession of land since 1996 till the date of acquisition. Mr. So and so also submits that the respondents, more particularly respondent number 1 to 5, have paid rental compensation to certain landowners whose lands are also under occupation by the security forces for the period prior to the acquisition of land by award number so and so, and therefore the respondents are bound by the principle of staple acquisition.
All right, Mr. B. Picha, you need not read. I think ultimately it comes to that 2004 volume 4 again. Reference has been made in paragraph number
My lord,
9.
here in the case also, award was passed.
Award was passed, but rent was not
paid. Yes. Here the direction was given to pay the rent. My lord.
So that we can
My lord, now what is my case, my lord? I'm a blazer, my lord. I'm a blazer, and who am I, my lord? Para 2 of my writ petition. The petitioner begs to state that petitions number 1 and 2 are by profession farmers and solely depend on cultivation and rearing of animals for their sustenance. And petition number 2 is a bus conductor in Arunachal Pradesh State Transport Department. Now we are, my lord, a blazer, my lord. Now, my lord, estimate, my lord, and valuation of property, my lord, has to be done by the deputy commissioner. He is the custodian of the villages, my lord, in the district, my lord.
All right, Mr. Picha, what is this thing? There are only 3 petitioners here. You said they are
authority letter is there, my lord.
Authorized on behalf of whom?
By the rest of the villages, my lord. Households, man.
Where's the authorization?
Page 39, my lord.
39.
Yes, my lord. In the first, we have also stated, my lord.
How many of them villages means how much? 10.
There are 10 household, my lord, and 13 household by counting the petition number.
This award which you have shown me, this is for the benefit of how many people?
For entire community, my lord.
Entire community.
Yes, my lord.
But here before the court only there are 10 people.
In that respect, my lord, in that case, my lord, my entire my para 2 may be hard, my lord. Para 2, my lord. So however, acquisition of land measuring so and so acres in the year 2021 by the Indian Army, petitioners are left with remaining part of the area. It is imperative to mention that petitioners here in above are head of their family consisting of many brothers and sisters. It is because of the reason petitioners have been pursuing the matter before the government and before this order court to seek compensation for entire family members since inception. It is imperative to mention here in that after payment of compensation by the Indian Army for the area of 202.5 and 63 acres of land, petitioners have divided the compensation amongst themselves without any disagreement or objection. Likewise, in the instant writ petition is allowed. The petitioner will again distribute the lease rent amongst the villagers without any disagreement.
Okay, now as per the award at page 72, annexure 12.
Yes, my lord.
It has not been apportioned to the individuals concerned.
My lord, why this, my lord? 4%, my lord. Because the earlier writ petition, my lord, the first round of writ petition, my lord, these 4 petitions were the writ petitions, my lord.
No, that's okay. My question was just little different. Annexure 12, page 72, it says private land. It covers so many and this is the amount.
Yes, my lord.
Where is the apportionment? Where is the apportionment showing the share of each of the family or each individual?
We have distributed within our by computing the share house of land holdings of our village.
How is that? How is that? You show me the method, how it's done.
But there is no disagreement within the villages.
That is something, that is not the point. Thing is that in other places we see that there are these individuals,
my lord,
A, B, C, D,
my lord,
it runs on and on.
my lord.
List of names
Yes, my lord.
who has got pass or who has this land holdings that has been identified. And accordingly, each of the share is mentioned in the award.
Yes, my lord.
The collector makes the apportionment.
Yes,
This much for this much of that. That long list is there.
yes, my lord.
But here it's like, it's just one list. It says that private lands.
There must be some representation by the villages, my lord, this four petitioners, my lord, or this writ petitioner, because my lord,
So how is the award received by each of the individuals? Who divides it?
my lord, it is the deputy commissioner, my lord. Because
So-
award is passed by the deputy commissioner. Now the deputy commissioner will disburse the compensation amount.
So
not
where is
by-
the document showing the disbursement to each of the individuals?
But it
is
is
not
with
there.
the record of the deputy commissioner, my lord.
But you are the petitioner, so you
Yes,
should
ma'am.
know.
Yes, ma'am.
You have also received the compensation.
Yes, my lord.
How have you received?
But on the holding of, my lord, the lands by the private, my lord, this households, my lord.
No.
If say suppose there are 13 households, my lord,
Hmm.
some, my lord, household, my lord, has, my lord, better land holdings, my lord, has a good number of land holdings, my lord. So which of the land, my lord, has been, my lord, disturbed by the compensation, my lord, by the land acquisition, my lord,
Who will decide that?
that will be decided by the deputy commissioner, my lord.
So you mean to say the deputy commissioner has made the apportionment?
My lord, yes, my lord.
Who will get how much and on what basis?
That, my lord, since this is a,
Because confusion will be created. Like supposing Mr. A and Mr. B is getting the apportionment.
my lord,
One says that no, my land is bigger than this. Why are you giving me this much only? B will say, no, this is my land.
my lord,
Why should you get the better share?
my lord,
So that problem will be there.
my lord, my lord, till date there is no litigation as such, my lord, against each other, my lord.
Fortunately, it's not there, but ultimately we don't know what will happen.
No, my lord, the
Because
major
people are
part of
coming. See, people are coming.
My lord.
Like the other day, we were discussing about the road construction by the NRGS
My lord.
under the NRGS scheme.
My lord.
And according to the respondents, they said there is no component for compensation.
My lord.
Petitioner says, no, my land is taken away.
My lord.
And the respondent says, no, there is an agreement. There's a society or something like that.
My lord.
Petitioner says that I'm not a member of the society. So this confusion goes on and on.
My lord. No,
Because this group will be there who has received, this group will be there who has not received.
but
So will that be your fate also?
no, my lord.
No, irrespective of whether you have the right or not, that will be decided.
My lord.
Supposing even if you have the right,
My lord.
but who will get the money and how much?
It will be distributed by the deputy. But in our case, my lord, in our case, there is no litigation pending, my lord, because we have distributed within ourselves, my lord, without any, my lord, objection from anyone, my lord.
So how have you distributed? You tell us.
But they would
Sometimes you say you have distributed, sometimes you say collector has distributed.
collector, my lord.
Who has distributed? Because the award here is only just one page. It says
Yes, ma'am.
this is the amount.
Yes,
and
ma'am.
the remarks is that private land.
Yes, ma'am.
And how many people are there in that private land?
But in fact, my lord, otherwise also, my lord, there is no, my lord, dispute within the villages, my lord. Because the major chunk, my lord, the major compensation has been distributed amongst us, my lord. This is only for rent, my lord.
See,
And the notification, my lord,
this is for rent only, whatever it may be.
my lord.
Not just one person will get for everybody over.
My
It
lord,
cannot be that everyone should get their own share
my lord.
because this portion of the land was looked after me. This is my land. He said, this is my land. Everyone will have their own individual area.
My lord.
So they should get their own respective share.
My lord.
How to get that? This is
Sometimes,
the question.
sometimes what happens, my lord, these villagers, my lord, they submit a representation before the deputy commissioner to deposit the account in the name of one person, my lord, and they will share amongst themselves, my lord. That is the case, my lord.
No, those arrangements are there. I don't know. If persons accept it, no, well and good. If the deputy commissioner also says, okay, well and good.
Yes, my lord.
But end of the day, unless there's a specific apportionment, which is as permissible as under the Land Acquisition Act, the old one, and even in under the 2013 Act, there must be a provision that who should get how much and how the portion has to be done.
Because, my lord, may see, my lord, the facts of the case. Since 1980, the land has been under occupation of the Indian Army. Now the assessment cannot be done by the villagers, my lord, this much portion is mine, this much portion is mine. It is on the understanding of the villagers, my lord.
So who owns the land then?
My lord.
The community owns the land.
My lord, the private, my lord, the villages consisting of this 13 household, my lord, they are from Bomdir village. They used to settle there, my lord. So there is an my lord, understanding that it would be shared by within themselves, my lord. And there is no dispute because this notification was also issued in the year 2021. Award has been passed in 2021, my lord. It was also published in the local dailies, my lord. There has been no objection from any corner, my lord. So we have been happily sharing our compensation with each other, my lord. Since there was a paper publication also, my lord. Gazette notification was also there. So, my lord, there is no dispute within ourselves.
Now what is the award? Page 72.
Yes, my lord. Page 76, my lord. This is the four my lord, individuals, my lord.
There are 4 names they mentioned here.
Yes, my lord.
Only these 4 persons have received it.
Yes, my lord. And distributed within, my lord, these 4 are representing their families. These 4 members, these 4 individuals are representing their family, my lord.
Their
There are
family.
many households, my lord. It is not that these 4 households are there only. There are many households, my lord.
How they're dividing this money?
My lord,
How they have divided the money? Sharing, then Tashi, then this is Norbu,
yes, my lord.
then how many petitioners? 3 petitioners, isn't it?
3 petitions are there, yes, my lord.
But here there are 4 names.
Yes, my lord. Now, my lord, all the person cannot come before this honorable court and swear affidavit. Because of that, my lord, the authority letter was signed, my lord.
Sharing, then Lobsang, Tashi. So Tashi Pema has not come.
Tashi Pema has not come.
The others have come.
Yes, my lord.
So Aadhaar card number, amount payable to each is there.
Yes, my lord.
Bank account is there.
Yes, my lord.
So this amount which is given to each of them,
Yes, my lord. And it was shared within the village, my lord.
it's been shared within the village.
Yes, my lord.
And the amount is also equally divided, it seems.
Yes, my lord.
Who's appearing for the DC?
My
Deputy
lord,
Commissioner?
my lord, I am ready.
How you distributed the money? How have you disbursed the money
My lord,
to these
to
4
the-
persons?
Yes, my lord. To these 4
These
persons.
4 persons.
Yes. As per the records. Otherwise,
They represent certain families,
some,
not only themselves.
not only themselves.
Okay, there's no dispute about it.
Yes.
Because why I'm asking all this, because later on, there
Yes,
should
my
not
lord.
be a complaint, saying that I'm left
This
out.
has been
He has-
paid to these 4 persons. Whether these 4 persons have paid to others, that knowledge.
That will not have, it will
Yes.
need not have. But that much trust they have on each other.
Yes, maybe.
4 persons are sufficient to represent all the people
No.
for whom, for the entire area of 202.56
202 acres.
acres.
Yes, my lord.
So these 4 persons ensure that all those persons who are affected by the acquisition of 202.56 acres are equally given. I mean, they are given their share.
As per records.
Okay, that is your case,
My
Mr.
lord.
Picha. I think you've done your job.
One thing, my lord. Lastly, my lord. My lord, due to inaction of the deputy commissioner, my lord, we have been denied of rent, my lord. So, my lord, the issue of maintainability, my lord, your lordship has raised, my lord.
Maintainability of what?
On that, while passing the award, why I have not filed any complaint before the deputy commissioner? My lord, this is delivered by your lordship, my lord. Para 4, my lord.
Yes, I am aware of this case.
Yes, my lord.
I'm aware of this case.
My lord, yes, my lord. Here also in the case, my lord, award was passed, my lord. And then after passing of award, the petitioner has approached the High Court, my lord, for, my lord, the solution and interest, my lord. Now, my case also, my lord, award has been passed, my lord, only that rent has not been paid to me, my lord. Now, this honorable court said, my lord, by this judgment, my lord, the writ petition is maintainable, my lord.
This was regarding solution interest.
Yes, and my
First
case
case
is
is
for
for-
rent, my lord.
For rent.
Yes, my lord.
Okay, let us.
That
get
is
the other
after passing of the award, my lord.
Yes, who will submit now? Mr. Yes, you are for?
Respondent number 1 to 4, Lordship.
Who are they? 1 to 4?
They are Union of India. Lordship.
Yes, what is your stand?
You know, see, firstly, the land was acquired under the Land Acquisition Act of 2013. Lordship.
Yes.
And there is no provision for lease rent, Lordship. Whatever is payable, Lordship, it has been clearly indicated in the act itself, Lordship. There is no mentioning of any lease rent. And secondly, Lordship, the petitioners themselves have allowed the Indian Army to use the land. They have permitted the authorities to occupy the land. And thirdly, Lordship, there is no any lease agreement between the landowner and the Indian Army. And in absence of such lease agreement, Lordship, the petitioner cannot claim for lease rent. And moreover, Lordship, in the year 2014, the Indian Army has requested the landowners to lease out the land, but they flatly denied, Lordship.
When?
In the year 2014, Lordship. Kindly see page 43, Lordship, of my affidavit in opposition, Lordship.
They wanted to lease out the rent,
Yes.
land?
Then, Lordship, they have flatly denied, Lordship. May I read, Lordship?
Let me see the affidavit first before you read.
Yes, Lordship.
We'll read together. Which one? Which affidavit? Your
Page
affidavit?
43, Lordship, annexure 10, Lordship.
Page 43.
Yes, Lordship.
Yes.
May I, Lordship?
Yes.
Most respectfully, I beg to inform you that in pursuant to your letter dated so and so, I have convened a meeting with the villagers. In the meeting, the villagers unanimously decided not to give our land at LGG Glengrove on lease basis. Instead, we are willing to part with our land to use forever if you desire to acquire our land by giving adequate compensation. Therefore, it is requested you to either return our land or acquire our entire land occupied by you following acquisition processes. At one time, Lordship, they are refusing to lease out the land, Lordship, and on the other hand, they are claiming lease rent. That too after receiving the adequate compensation, Lordship. So, my lord, in view of this.
So
Lordship,
where is your letter dated 19/2/2014? Do you have it annexed?
Page 41. Lordship.
42, I think.
42. May I read this? Refer to meeting held at headquarters 40 Mountain Brigade on 27 January 2015 regarding hiring lease of land. You are requested to forward no objection certificates on the following matters NOC for lease for 99 years. Whether there is any political, religious or other objection. This is to inform that proposal for subject matter can only be taken up for lease after obtaining the requisite certificate from your end. And early action is requested.
So hiring and lease of land, some talks was going on.
Yes.
Their reply is that they don't want to give it for lease, on lease. And if you want it, you can acquire it. So now they cannot say that they cannot ask for rent. They themselves have said that they don't want to give this land for rent. But yet the question of yet you have occupied the land since 1980, isn't it?
That is also not clear.
What not clear? What do you mean not clear?
There is no specific.
What about the earlier writ petition? It was where it was recorded clearly that you have been occupying the land since 1980.
That writ petition also say no specific date has been given.
Year is there, 1980. So if it's 1980, that means January 1st of 1980.
It's also not specific. And moreover, Lordship, the petitioner themselves have allowed, Lordship, the authorities to occupy the land. Lordship. In the pleading of the petitioner itself, Lordship, it can be gathered. Lordship. They themselves have allowed. Lordship.
How? Verbally?
Lordship.
Verbally? Is it in writing that we have allowed you, please occupy our land, this vast land, it's all yours, please occupy? Any letter like that? There's no letter.
There's no record.
Basically, it's assumption. Since they have not objected, that means they have allowed. That's what you say.
In any case, Lordship, there is no provision for lease land, Lordship, under the Act, Lordship. And the land was acquired under this Act, Lordship, 2013. Lordship. And under the Act of 2013, Lordship, there is no provision for lease land.
What is the Act of 2013 for? This is for acquisition.
Yes, Lordship.
This is not for rent. So if it's not for rent, then obviously it will not be there. What is there for rent then? What is the provision? Yes, anything else? You want to submit?
Even if assuming Lordship, not admitted that Lordship, the rent has to be paid, Lordship. In that case also, Lordship, on what basis the rent has to be assessed, on what basis the rent has to be calculated or determined, Lordship. That is also not clear.
This notification of 18/9/2018 is not available
No.
to anyone. No one has produced it. This is only an estimate, isn't it?
Yes.
This is not the actual thing which has been relied upon. It is only an estimate. Yes, that's all. Yes. Mr. Ratan?
My lord, at the outset, my lord, I'm not against the petitioners for getting their rent, my lord. But whether a REIT will be maintainable for claiming rent, my lord. That whether this REIT petition in the present form will be maintainable. That is the only this. Here, my lord, occupation is from 1980 onwards, my lord. Whether the initial occupation was with permission, without permission, consent or not, whether there was any agreement to that effect, that lease will be, a rent will be given. These are things to be determined. From when did the occupation started to become unauthorized against the will of the landowners? That has to be determined. Prior to 2010, there was no complaint that you have to pay rent or not. Only after 2010, from records, what we gather, from 2010 onwards, they have started for acquiring the land for payment of compensation. Prior to that, there was no claim for rent. Now, if under 226, it is for enforcement of fundamental rights and other legal rights. My lord, whether this legal right for claiming rent will be there, will be included in the other legal rights. My lord, to claim rent, my lord, first of all, to my understanding, there has to be some agreement between the parties that, okay, you occupy this, I'll pay you the rent so much. Now, whether there was any agreement to that, to my understanding, there is no agreement. In the absence of this agreement in the form of contract between the parties, whether a REIT court can direct that since you have occupied, you have to pay the rent. Of course, they are entitled to rents, but not in the form of a REIT petition. They can claim in civil suit, file a civil suit, and then that will be the appropriate, not in the shortcut in the form of a REIT. Here, many things has to be determined, whether the initial occupations were with permission or without permission, from when will be the rent payable. Otherwise, the petitioners will claim that we did not permit since the initial occupation. But claim for compensation started only in the year 2010, I believe, complaint. And the REIT petition for acquisition of land was filed in 2014. To that effect only, the maintainability, although my learned friend has shown this order passed by this coordinate bench where certain directions have been given to conduct a joint survey to determine from which year and what is the area, and then pay rent. That order has been given. But in that order itself, which was read out by my learned friend, if my lord kindly sees the judgment of Tasi Pujan, WPC 258/2023, that was supplied, my lord. Tasi Pujan, my lord. I'll take my lord from page, paragraph 6, my lord. And paragraph 6, end of paragraph 6, my lord, the next page, my lord. In line, after line 3, my lord, Mr. Majumdar also submits in the middle, my lord, that the petitioners have also prepared one writ petition being WPC number so and so, wherein this court was pleased to issue direction for paying compensation to the landowners. After taking a decision regarding the area of land being occupied by Director General of ITBP, and while disposing of the petition, it appears that the compensation to be paid for acquiring the land would not include any rent that may be entitled to earlier period for occupation from 1962-63. However, liberty was granted to the petitioners to file a fresh application, and accordingly, petitioners have approached this court by filing the present petition. Of course, they also have filed a writ petition. Here, to my understanding, the earlier court also did not entertain the claim of rent in that WPC 8 of 2021 to make a fresh petition before appropriate court, my lord. Now, therefore, my lord, although in this order, there has been certain directions, but whether a writ can be maintainable and the other judgment which my learned friend has relied on, 2004-2, the very paragraph, paragraph 18, 2004-2, yes, my lord.
2004, I think.
4-4, yes, sorry, my lord. 4-4, page 79, my lord. My learned friend relied on paragraph 18, my lord.
Yes.
My lord, in paragraph 18 also, it says, in a case where the landowner is dispossessed prior to the issuance of preliminary notification under section 4(1) of the Act, the government merely takes possession of the land, but the title thereof continues to vest with the landowner. It is fully open for the landowner to recover the possession of his land by taking appropriate legal proceedings. Here also, legal proceedings, even for rent also, legal proceedings, although here the apex court has said at the time of computing the compensation, this rent also could have been added, my lord. But that opportunity also they have not availed. Other appropriate legal proceedings would not mean, my lord, to my understanding, that it will be by way of a writ, my lord. Okay. Then, my lord, another judgment, my lord, time and again, my lord, this basically is for rent. Whether this is a private right which is claimed by the petitioner. If from our state only, this went up to the Supreme Court, RK Mission versus Kagokunya. My lord, what private whether courts should entertain private rights, my lord.
Mr. Ratan. Ultimately, if the compensation or rent is to be paid, who will pay? State will pay.
No, my lord. That's why it is only. I'm only for whether the court can permit such. Only to on the legal point. It is if they agree, the army authorities agree. .
Which paragraph you referring to?
my lord, okay. I'm sorry, my lord, Cargo Kunya. If Cargo Kunya.
Yes,
Cargo Kunya, yes, my lord.
I'm holding it.
Oh,
Kago
yes.
Kunya.
Para 29, my lord.
Yes.
Moreover, recently in KK Saxena International versus so and so, another two judge bench of this court held that writ would not lie to enforce purely private law rights. Consequently, even if a body is performing a public duty and is amenable to the exercise of writ jurisdiction, all its decisions would not be subject to judicial review. The court held thus. What follows minute and careful reading of the aforesaid judgment of this court is that if a person or an authority is state within the meaning of Article 12 of the Constitution, admittedly a writ petition under Article 226 would lie against such a person or a body. However, we may add that even in such cases, writ would not lie to enforce private law rights. There are catenary of judgments on this aspect, and it is not only necessary to refer those judgments as that is a basic principle of judicial review of an action under the administrative law. The reason is obvious. A private law is that part of a legal which is a part of common law which involves relations between individuals such as law of contracts or torts. Therefore, even if writ petition would be maintainable against an authority which is state under Article 226 of the Constitution before issuing any writ, particularly writ of mandamus, the court has to satisfy the action of such an authority which is challenged is in the domain of public law as distinguished from private law.
Okay.
This is purely a private right they are claiming of for payment of compensation, rent. Payment of compensation acquisition, that could have been understood. It is under the statute they are bound to pay. But for rent, there has to be some determination. Well, only that's all.
Mr. Kamdul is there?
It may, my lord, the role of the government comes only on the receipt of the requisition letter, my lord, from the user agency, my lord. This, my lord, the period from 2010 to 1982 to 2000. It was in fact the purely, my lord, this private arrangement, my lord, in between the petitioner and the army, my lord.
Okay.
With government did not allow neither settle here, take the petition, my lord. There is no any order from the government, my lord. That was purely understanding between the petitioner and the Indian army, my lord. So therefore, unless, my lord, our any act of the state is challenged, my lord, we don't have anything to say, my lord. Only after the issuance of notification, my lord, if the petitioner is saying that no compensation is being paid to them, then only, my lord, we can clarify that, my lord. The period between, my lord, from 1982 to 2020, my lord, it is purely this private arrangement, my lord, in between the petitioner and the Indian army, my lord.
Okay.
We do not have any role in this period, my lord. So therefore, my lord, from the side of the state, my lord, we do not have any thing to submit, my lord. If petitioner is saying that after the issuance of notification, there is some discrepancy in this distribution and all, then only, my lord, we can clarify, my lord.
All right. Please write down. I heard Mr. B. Picha, learned counsel for the petitioners. Your good name?
Loyal,
K. Loyam.
Loyal, Loy.
Mr. K. Loyal, learned CGC.
CGCA.
For the respondent,
1 to 4.
numbers 1 to 4. Mr. N. Ratan, learned additional advocate general.
For 6, ma'am.
For respondent number 6 and Mr. D. Kamduk, learned standing counsel, land management department. For respondent number 5. So by filing this writ petition, the petitioner has sought for a direction to the respondent authorities to process evaluation of rent from the year 1980 till the year 2021. For an area measuring 481.41 acres located at LGG bracket Glengore, close bracket, under Bomdir village in Kitpi circle in the district of Tawang, which has been unauthorizedly occupied by the Indian Army. Next para. It is the case of the petitioners that the land concern been inherited by them from their ancestors and is used for cultivation purposes. So while the petitioners were enjoying their land, peacefully, without any disturbance from any corner, the Indian Army in the year 1980 started entering into the land and later occupied the same without any permission from the petitioners. Stop. Although the petitioners had raised objection against the occupation of their land, but they have been told by the army personnel that they would be only using certain plots of the land, and that also for a few years, purely on temporary basis. Stop. With such assurance, the petitioners had allowed them to use it for a few years. But since the occupation of the land process, the petitioners submitted a representation before the commandant, 190 Mountain Brigade, LGG Tawang, on 11/8/2010, requesting the payment of adequate compensation for occupation of their land. Stop. Despite such request, since no steps were taken by the army personnel, petitioners approached the Deputy Commissioner Tawang, and the Deputy Commissioner, by letter dated 16/8/2011, wrote to the Commander 190 Mountain Brigade requesting no, 190 Mountain Brigade and 40 Mountain Brigade, requesting them to where's that letter, Mr. Picha?
Page 44, my lord. Type copy, my lord.
Requesting them to take up the land acquisition case for the areas they have occupied. What did I say? In coordination with the what is the full form of DEO? Defense, isn't
Defense
it?
Asset Officer.
With the defense, in coordination with the Defense Estate Officer, bracket DEO. In order to avoid dispute with the villages. Stop. Next para. Accordingly, a joint survey for land acquisition at Lungro GG was carried out from 18th to 19th June 2012 for a total area of 481.41 acres. And the map of survey, the map of the surveyed land duly signed by the landowners, Gabras within bracket GB and Circle Officer Kitpi, is it? Or Kilpi?
Kitpi.
KIT. Kitpi were obtained. And the same was forwarded to the Circle Officer Land Management under the establishment of Deputy Commissioner Tawang. Stop thereafter. The army authorities wrote to the Divisional Forest Officer, bracket DFO, Tawang, informed the latter that a total of 481.41 acres of land was required to be acquired at LGG. And that the land had been surveyed and NOC obtained from the landowners and forwarded to the circle officer, IPTI, and also to the Deputy Commissioner's office at Tawang on 10/8/2012. So as such, forest clearance for the said area of land was required to the army authorities to process the case further. So thereafter, pursuant to the government's notification number LR-152/2010/1811 dated 14/3/2011, a physical verification of the entire project area of LGG bracket 481.43 acres was carried out by the members of the on 14/6/2014 to verify the extent of the community land, individual land and forest area to be acquired for the purpose of acquisition of the land. And the constituent committee recorded its findings for 481.43 acres of land. You're concerned with serial number 3?
Yes, ma'am.
Wherein the private land with individual customary holding with forest cover was found to be 160.5 acres and without non-forest cover as 320.93 acres, thereby totaling to 481.43 acres. So since further steps was not taken for acquisition of the land, the petitioners approached this court by filing WPC number 390 AP 2015. Claiming compensation for occupation of their lands by the Indian Army. The writ petition was disposed of by order dated 2/3/2016 with a direction that the respondent authorities, if so desire, should acquire the land of the petitioners in terms of provisions of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013, open bracket, Act of 2013, close bracket. And if not, to vacate their land on payment of reasonable compensation for their occupation since the year 1980. Next para, pursuant to the disposal of the said writ petition, the approval for acquisition of 481.41 acres of community land was given. What did I say? Ministry of Defense in principle. And the headquarters Eastern Command was asked to prepare board proceedings and to forward the same to the Army headquarters for according government sanction. Stop. In the meantime, the Defense Estate Officer, or you write DO. In the meantime, the DO, Tezpur Circle, White communication dated 26/5/2017, wrote to the Deputy Commissioner, Tawang, to provide the revised cost for 481.41 acres of land after giving due consideration of the appropriate land as per ground reality. Mr. Picture, where is that scaling down to 202 acres?
64, page 64.
Stop. However, by a subsequent commission made by the DO, Tezpur Circle, dated 8/9/2017, to the Deputy Commissioner Tawang, the area to be acquired was scaled down to 202.56 acres of the community land at LGG, and that the cost of the said area of land, along with all the NOCs that is required, was sought from the office of the Deputy Tawang. Stop. It was thereafter that a preliminary notification under section 11 bracket 1 of the Act of 2013 was notified on 5/1/2021 and which was published in the Arunachal Pradesh Gazette dated 25/1/2021. So out of the total assessed amount of rupees 37, 48, 27, 989, an amount of rupees 16, 68, 71, 004 was sanctioned and deposited before the Deputy Commissioner Tawang for payment to the landowners. Then what is this, an extra 14?
This is notification under section 19, my lord.
Stop. Subsequently, on 27/4/2021, the final notification under section 19 of the Act of 2013 was notified and the same was published in the Arunachal Pradesh Gazette dated 7/5/2021. This is 19 is possession.
Yes, right.
Stop. Upon issuance of the said notification, the balance amount of the compensation was deposited before the Deputy Commissioner Tawang and which was then disbursed to the petitioners. Although the petitioners were given compensation for acquisition of their land, but as rental compensation was not given to them, they submitted a representation before the respondent authorities on 23/1/2023. Stop. Since no further steps was taken apart from paying them the compensation for the acquisition of their lands, the petitioners being aggrieved are before this court through the instant writ petition. Next para, Mr. B. Picha, learned counsel for the petitioners, submits that. The petitioners are entitled to be paid compensation, rent for the unauthorized occupation of their land since the year 1980 till the date on which a notification was issued under section 19 of the Act of 2013. That is 27/4/2021. Stop referring to the order dated 2/3/2016, passed in the earlier round of litigation. The learned counsel submits that the claim of the petitioners that the army authorities have been occupying their land since the year 1980 without payment of any kind of compensation to the petitioners was accepted by the court, and therefore the direction was made to the respondent authorities to either acquire the land or vacate the same on payment of reasonable compensation for its occupation since the year 1980. Full stop. Full stop. The said observation and finding of this court has attained its finality, and that it was only in the year 2021 that the respondent authorities, acting upon the direction of this court, that the land was finally acquired, however, without paying them any rental compensation. So the learned counsel therefore submits that the respondent authorities should be directed to assess the rental compensation payable to the petitioners since the 1980 till the year 2021 in terms of the relevant guidelines in this regard. Stop in this connection. Now, we cancel that. In support of his submission, Mr. B. Ficha has relied upon the following authorities: R.L. Jain versus DDA and others, 2004, 4 SCC 79. Number 2, Radhi Shyam and others versus State of Uttar Pradesh and others, 2011, 5 SCC 553. Next, number 3, Hindustan Petroleum Corporation Limited versus Ashok Rangha Ambre, 2008, 2 SCC 717. Next, Ali Hussain Barbuya versus State of Assam and others, 2022, 6 GLT 513. Next, Srimati Lal Nunthari versus Union of India and others, 2003, sorry, 2023, then separately 0, Supreme bracket Gov GIU 1293. Then Young Lai Association. Represented by its president, Sri Aldrin Lal Chanpuya and another versus State of Mizoram and others. Two 2017 4 GLR 134. And next, judgment and order dated 21/3/2024. Passed in WPC number 258 of 2023. Open bracket. Tashi Pujan and another versus Union of India and 8 others. Close bracket. Next para. Mr. So-and-so, learned CGC, submits that. On the other hand, submits that there is no provision for payment of lease rent under the Act of 2030. And in fact, the estimate relied upon by the petitioners at Annexure 17 is very vague and does not reveal as to how the rent is to be calculated. Stop. He submits that. It is also questionable as to whether the government approved rate notified via notification dated 18/9/2008 would be applicable to the case of the petitioners, since the petitioners claim that their lands have been occupied unauthorized since the year 1980. So the learned CGC further submits that the army authorities had even approached the petitioners as to whether they are willing to lease out their land on rent for a period of 99 years while seeking no objection from them. But such requests were flatly turned down by the petitioners. Stop. It was their demand that their lands should be acquired permanently instead. Therefore, as the lands have already been acquired, no further payment is due to the petitioners. Anything else I missed out? Next para, Mr. N. Ratan, learned additional AG, also submits that the very maintainability of the claim made by the petitioners for payment of rent by invoking Article 226 of the Constitution of India. Is under cloud. CLOUD, under cloud. Since such a claim is essentially of a civil nature, which requires to be adjudicated before a competent civil court. Mr. Ratan, what else did you say?
Well, I rely on the same paragraph, 2004 4 SCC, page 79, paragraph 18, which the Honorable Apex Court itself has said that for rent of claim rights over the land, appropriate legal proceedings would have been
Okay.
initiated.
In this connection, the learned additional AG relies upon the case of R.L. Jain Supra, wherein the Apex Court has held that in order to claim rent, appropriate legal proceedings is to be initiated before the competent court. Competent civil court. Then what else?
Then, my lord, 2019 SCC, my lord. Yes, 1916 SCC 303, Ramakrishna Mission versus Kago Punya. I rely on paragraph 29. Writ would lie to enforce purely private law rights.
Stop. He also submits that since the claim urged by the petitioners is a private right, a writ would not lie. Stop. In this connection, he relies upon the case of Ramakrishna Mission and another versus Kago Kunya and others.
2019-16 SCC 303.
Reported in 2019-16 SCC 303.
Paragraph 29.
It's okay. Got it. You had also submitted something else. What was that?
Paragraph 29.
That I've seen.
Yes, madam. Therefore, writ will not be maintainable here, and then appropriate, you'll have to.
He therefore submits the petitioners should approach the appropriate forum with their claim for payment of rental compensation. All right. Next para, Mr. D. Kamdu, Learned Standing Counsel, Land Management Department, also adopts the argument of Mr. N. Ratan, Learned Additional AG, and submits that the claim of the petitioners is mainly between themselves and the Indian Army.
Yes.
And that the state has no role to play at this stage. Next para. I have heard the submissions made by the learned counsels for the rival parties. And I have perused the materials available on record. The rest I'll continue later on. God bless you. Yes, all right, we'll get the orders maybe by tomorrow. Yes, ma'am. God bless you. District.
My lord. My lord, petitioner herein
Yes.
is a engineering graduate from Tato, Siomi district, where the 700 megawatt hydroelectric project is being undertaken by the NIPCO. Lord, the case of the petitioner is that the Deputy General Manager, Human Resource Department of NIPCO has requisitioned for appointment of 12 JE mechanical and 6 civil.
Show me the document. Page, the next step. Advertisement was issued?
Yes, Lord.
Where is the advertisement?
29, phase number 29.
Page?
29.
29.
Yes, ma'am.
29.
This is a notice
Circular.
issued by the Deputy Commissioner in pursuance to the requisition letter made by the NIPCO authority. Whereby, my lord, the invitation, the application or from the eligible candidates were invited and set the 5th March as last date for submission of the document, my lord.
No, 5th March?
Yes, 5th March.
5th March?
Yes, ma'am.
So today we are on 12th March.
12th March, my lord.
Last date is over.
Yes, my lord, accordingly, the petitioner has applied for the post.
Okay. Which post?
Junior Engineer Civil.
Okay. There are 2 posts advertised. Junior Engineer E&M and one is Junior Engineer Civil.
Civil, yes.
We are concerned with Junior Civil.
Yes,
Junior Engineer Civil.
Yes, madam.
How many posts?
18, total 18 posts. Engineer
posts.
Civil, there are 6 posts.
Just a minute, huh? JE. What is E&M? JE Civil. Civil is how much? How many posts?
6, madam.
6 posts.
Yes.
And for JEM?
12. ENM Mechanical, 12 posts. Madam.
Electrical and medical 12
Mechanical,
posts.
yes.
For civil, it's only 6 posts.
Yes, madam.
Okay.
Accordingly, the petitioner has applied. However, my lord, in phase number 30, my lord.
Page 30.
Yes.
There's a cutoff age, maximum age.
Maximum age is 30 and relaxation up to 35 years for APS ticket. So I am agreed by this.
How old are you?
I am 37 years old.
Then why did you apply?
Lord, for that I have already submitted the representation.
That you applied, it's 35 years maximum.
Yes, my lord, that is there, but in other cases, in other advertisement, generally the upper age limit is relaxed up to 40 years. Even in APSC examination, my lord. So my contention is that the petition, I may be allowed to participate, I may be allowed to sit in the recruitment process.
See, advertisement says this much, and if you're not this much within this limit, then how do we say that you should be permitted?
Yes, my lord.
Unless you,
Basically, these posts are reserved for the project affected families.
no, show me any authority, show me any notification where it says that it's up to 40 years.
Yes,
Then
my
we
lord,
can
definitely.
consider. Because at the outset itself, you are barred. It says 35 years, 30 years, and for ST, it's 35 years. And you claim that you are 37.
Page number 57, man.
57.
57.
On what basis you are claiming that you should be allowed?
This is the advertisement made by the Arunachal Pradesh Civil Service Commission, man.
57.
Yes,
For what post?
for various posts under Arunachal Civil Service. Even in, this is the highest examination in the state of Arunachal Pradesh. So I am claiming that my age may be relaxed at par with this advertisement.
How can you draw a similarity? This is under NIPCO, isn't it? NIPCO is different.
My lord, but these posts are basically meant for the project affected families. And in memorandum of agreement also, they have clearly stated that the preference would be given to the project affected families.
Maybe, but age, if your age is not within the limit, then what to do? What preference can be given to you? See, this combined competitive examination 24.
Yes.
Where is the age limit given? Which page?
Page number 57, man.
57.
Yes.
Serial number, age limit.
Subclause 2, subclause 1 month. Up to maximum of 5 years if a candidate belongs to Arunachal Pradesh civil scheduled tribe. So 35 and there again relaxed to 5 additional 5, meaning there are 40 years. And this is the highest examination in the state of Arunachal Pradesh. Basically, my lord, this project was supposed to be implemented in the year 2012.
No, see, this alone, will it be sufficient for you to be admitted for examination?
My lord, there are so many instances where the age upper age limit is made 40 years, my lord. Again, in my lord, here in this case, I have filed an RTI seeking details information regarding the recruitment rule, but not yet the authorities are punished.
When is the examinations?
My lord, the authorities are reluctant to provide any details regarding the examination, my lord. However, in every day, they are issuing press notification after notification.
But you are saying that it is very urgent.
Yes, my lord.
But now you don't know when it will be held.
Even, my lord, today also, this afternoon also, they have issued one circular that the recruitment would be carried out by the nearest employment exchange. Such kind of notification circular are repeatedly issued by the respondent authority.
No, as per this circular, what is the date fixed otherwise?
My lord, there is no any specific date.
Last date of application?
Only
is
5th, my lord.
5th March.
Yes, ma'am.
Thereafter, what will happen, you don't know.
For that, I have already applied RTI mine, but till that, no any response from the respondent authorities.
No, see, how do you claim relaxation up till, the claim up till 40 years? This is on the basis of one state combined comparative examination.
Yes.
Which is not an examination under NIPCO.
But my lord, NIPCO authorities, they don't have any recruitment rules. As I have already filed RTI. And even in a deputy commissioner, which CEOM district, I have made so many representations seeking the details on what basis the recruitment is going to be taken place, but no any response from the respondent authority. So this is how I am highly prejudiced. At least I being the unemployed educated from the project affected families. So preference should have been given to the petitioner.
Preference will be given to you when all things are equal.
Yes, But my lord, how these rules and how these guidelines has been
All
framed,
things are equal.
that is not what.
But one is a local, one is a non-local. So
Yes.
preference will be given to a local.
Yes.
But not because, not unless you are at par. How do you get the preference? See, prescription of this circular, you should be 30 years. And if you are an ST, you'll be given 5 years benefit of 35 years, up to 35 years. That much only. And there's no such guidelines as such to show that this age is relaxable or further relaxable. What you're showing us, me, is only this advertisement by the APST.
Yes, my lord.
How can you draw a similar thing with this APST thing?
Yes, exactly. This is my case, my lord. I have sought an RTI and I have approached to the Deputy Commissioner for details of the information under which provisions and under which recruitment rule the present is going to be held. But no any response from the authorities.
Okay, that is one thing. But under what provision can your age be relaxed? Tell me. Just because one advertisement says 40 years, you said I also should be given 40 years. That advertisement is in respect of something else in the state by the Public Service Commission.
Yes, my lord. That is the only basis that I am claiming the parity. My lord.
That is not enough.
My lord, I will satisfy in coming days that in so many cases, so many instances, the age is relaxed up to 40 years. My lord.
You satisfy, but that's all. Only notice will go. Beyond that, nothing can be done.
At least, my lord.
You're expecting that you should be allowed to sit exams.
Yes, my lord.
Isn't it? But you don't know when the exams is going to sit.
Yes. Otherwise, my lord,
how can we pass an order in openly like that? Whenever exam is done, whenever this is done, he should be allowed.
Even that details, my lord, they are not providing. This is how I am prejudiced, my lord, by the act of the respondent authority.
See, once the examination will be notified, otherwise, how will the candidate know? Suppose the candidate has filed the application, he might want to go somewhere else, in different state, for 2, 3, 4 days. And in his absence, suddenly, if exam is conducted, it will be difficult. So that's why, hopefully, the authorities will notify, said exams will be conducted on this date, on that date, interview on this date, like that. Then in such a situation, you may press your prayer.
Yes.
But as of today, I don't think we can't give you such kind of blanket order.
Otherwise, my lord, my various representation is pending before the authorities. That may be disposed of. This direction may kindly be issued.
Where is your representation?
Representation dated 27 to 2020. Page number 105.
Huh?
Page number 36. That is what?
36.
Yes.
How have you annexed your representation? You have submitted representation even before filling up the form.
Yes. No, this Deputy Commissioner, that is 48, page number 48, my lord.
48. But who is this Deputy Commissioner to give you the relaxation?
Yes, Deputy Commissioner is the one who issued the advertisement.
Huh?
Deputy Commissioner is the.
I see.
Yes.
Let us see how he has issued the advertisement. But is he the authority?
Yes, my lord. NIPCO has wrote a requisition letter to Deputy Commissioner. Accordingly, the Deputy Commissioner has issued this circular, inviting the application from the eligible candidate, setting the 5th March as last date. This is the only communication that we could access from the office of Deputy Commissioner.
So Deputy Commissioner is acting on behalf of NIPCO.
And NIPCO has written a requisition letter to
Correct.
Deputy Commissioner. Yes.
So whether Deputy Commissioner can relax your age or extend your age?
Yes, my lord. Accordingly, the Deputy Commissioner has issued this impugn advertisement.
Correct. But he has not issued this advertisement on his own.
Yes, ma'am.
It will be guided by the NIPCO guidelines, isn't it?
Yes, my lord.
Is there any standing counsel for NIPCO? No, what is the situation like? NIPCO wants to employ somebody.
Yes, my lord.
NIPCO wants to appoint somebody
yes.
or engage somebody. then requisition sent to the deputy commissioner.
Yes, deputy commissioner.
And,
And
and deputy commissioner cannot give his own whatever he wants to advertise. He has to issue the circular in terms of the requisition. So the NIPCO says that these are the terms. We want this much engineer, that much engineer, civil, and one is electrical and all that. And that they should be within this limit. And deputy commissioner has issued it.
Yes, I have already approached the NIPCO authorities also. But
Sorry?
from there, there is no any such instruction and direction to the deputy commissioner that age limit should be such and such. NIPCO authority has replied.
Okay, where is your representation? Have you stated anything regarding the combined service examination?
Yes, page number 48, madam.
Have you stated?
Yes.
IPC, okay. So you say that the
Para
commissioner
six.
is, you say that the deputy commissioner is competent.
Since the deputy commissioner has issued the advertisement, so he is the competent to look after the contention raised by the petitioner.
No, I don't know. You're saying that NEPCO has never instructed that this much should be the age bar or that much should be the age bar. It is the deputy commissioner who has put this.
Yes.
You're saying that.
Yes, madam.
From where you're saying
So
that?
now, my lord, deputy commissioner is the right person to
No, from where you're saying that NEPCO has not given any such kind of age limit.
We
But
have
it is
been,
the deputy commissioner who has given the age limit. From where you're saying that?
my lord, we have been personally to the NIPCO office, and
Is
we
it-
have submitted a representation there also.
So is there any document to that effect? Your submission will not do. You are to give us the document saying that NEPCO has not said anything, given any age bar. Simply requisition was given to the deputy commissioner, and deputy commissioner on his own has given this age, that 30 years plus 5 years.
Even, my lord, details of the advertisement, the copies, these details of the advertisement are not even furnished to the petitioner, my lord. Only two annexures are being furnished to the petitioners. One that is the impugned advertisement, and one is the format, application format only.
Now, who will conduct the exam? Who will conduct the exam?
Probably, my lord, deputy commissioner will conduct the, yeah.
Probably. See, we don't know.
For that reason only, my lord, we have filed RTI, seeking all those details.
Can't do anything much.
My RTI is on page number 103, my lord. 103, my RTI.
Yes, what is there in the RTI?
My RTI, my lord.
Hmm? What have you asked for?
Details of information, my lord. Copy of advertisement for the said post. Copy of letter received from chief manager, human resource, white so and so. Copy of application forms. Copy of all annexures, all the relevant documents. The applicant, all other applicants, they're applying only on the strength of the circular issued by the deputy commissioner only, my lord. Otherwise, there is no any such.
That's okay. So there's no such document, fine. But my question to you is that whether deputy commissioner can consider your representation when recruitment is to be done for a job in the NEPCO. Like in the state government also, this department, that department, they want some recruitment for this job. And they make the requisition from the APSC. APSC, isn't it? APSC.
Yes.
So APSC will be guided by the recruitment rules.
Yes,
They will be
recruitment.
guided with the instructions from the personnel department or whatever. So on their own, they cannot give this much limit, that much limit. Likewise, the deputy commissioner is also acting on behalf of NEPCO only. So
at this stage, my lord, at least deputy commissioner may be directed to dispose of the representation.
see, I have no,
Otherwise, he is the competent to decide whether my represent is to be considered or not.
there is
Since
no
he has
difficulty in directing,
Yes.
but whether deputy commissioner is the right person or not, that is what I'm saying.
If, my lord, if deputy commissioner doesn't have any authority, then he may again return to the NIPCO authority.
Who are the respondents here? Secretary Power. Deputy Commissioner also is there. Mr. Ratan, what do you say in this matter?
In fact, instead of Secretary Power, it should have been Secretary Hydropower. Memorandum of agreement has been entered between, in the name of Governor of Arunachal, but by the Commissioner Hydropower.
So there's a different secretary for that?
Yes. there's a-
Hydropower.
Yes, Commissioner Hydropower is different, Commissioner Power is different.
So NIPCO comes under hydropower.
No, my lord. NEPCO is totally different. This
Government-
MOA at page,
NIPCO has entered into a MOU with hydropower.
yeah,
No,
with the
with Government of Arunachal Pradesh.
government, which was signed by the Commissioner Hydropower, not Commissioner Power. We have two different departments, power and hydropower.
So you need to amend your post title also.
Yes, my lord. And then, my lord will see the advertisement, circular itself, it's not an advertisement. Circular, it says, in pursuant to letter dated so and so, dated 13/1/2025, page 29 itself. Received from Chief Human Resource NEPCO regarding nomination of eligible candidates for the post of junior engineer, EM so and so, civil so and so. Therefore, eligible candidates interested in applying for the said post are to submit their names with all requisite documents in Xerox in the office of the undersigned on or before so and so. The application is available with Srimati so and so, DA office. Now, application also, my lord will find at page 34. Name and designation, name of the name and at serial number 3 at page 34, name and designation to whom applicant to report will be intimated through call letter. There will be a call letter that will be intimated by the NEPCO only. NEPCO will be conducting the.
That is why he's saying that the presentation was given to the DC.
Yes, my lord, that will not.
DC, what can DC do?
To whether there is any recruitment rule by the NEPCO or not, that has to come, my lord. Whether the relaxation of the state relaxation, if I believe there is a notification for age relaxation in the state, my lord. There is a notification, but whether the state government's notification will be applicable to the NEPCO, that also will be a question.
That's what.
This is not a recruitment by the state. And first of all, we'll have to get the reply whether they have a recruitment rule or any guidelines for this post. And in that, whether there is age limit given or not. So, my lord, what I would request my learned friend to withdraw this and come with proper documents so that if any possible help can be, relief can be granted by this honorable.
By then, my lord, recruitment process will be completed. my lord.
No, my lord, call letters will be issued that
No, my lord,
if others call letters.
You have submitted application.
representation before NEPCO authority.
No, not representation. Your application.
Yes, my lord.
You have submitted your application.
Yes.
So based on that application, the call letter will come to you.
My lord, my application will summarily rejected basing on the
See,
age.
So you know very well that your
But
case will
if-
be rejected.
If this, my lord,
Still you applied,
but if this-
knowing very well that you are not qualified, you applied, and now you come to the court saying that you please allow me to.
However,
Yeah.
my lord, the DC doesn't have any document to show that this is the recruitment rule and this is the criteria.
No.
So that's
What do you mean there's no document? What about this circular? It clearly says 35 years.
No, my lord,
You're going against 35 years. You know very well that you are overage, still you apply. At the same time, you're coming to the court, say that please permit me because Arunachal Pradesh Public Service Commission is allowing 40 years. That cannot be the ground.
my lord, for
This
that,
is not state, this is under NIPCO. Your representation is given to the deputy commissioner, who is only the authority to whom requisition was made. He cannot decide your representation. He will say, what can I do? This is the requisition. You go to the NIPCO,
For that.
That's what he'll say.
Yes. For that reason only, my lord, I
Then
have
you go to
applied.
NIPCO.
Yes, I have applied for the RTI.
You withdraw the
taking
writ
DPR.
petition and file a representation before NIPCO.
Yes, my lord, I have already filed, my lord.
Where?
Phase number 105.
105.
Yes.
Is this the competent authority?
My lord, this is the social organization, registered social body of my community, my lord. And this comes under the project affected area, my lord.
No, who has written this letter?
President of
This is not
the
your,
society, my lord.
this is not your personal letter.
But raising the contention raised by women.
This is some sort of an organization. What is this?
This is a registered society, man.
No, that is registered, maybe registered society, but this is not in your personal capacity.
Yes. This is the community's, my lord.
Community is not before the court, no?
Yes, my lord.
It is the petition in person who's come. Why should we direct the authorities to dispose of somebody else's representation, which is not even yours?
At least, my lord, I pray for some
I would suggest the
direction from this
authority
honorable
who
court.
has made the requisition to the deputy commissioner, that is the chief manager, human resource, NEPCO. I think it will be appropriate for him to make a representation. Page
Where is that page number?
29.
You submit your representation.
Page 29, circular, the circular.
You submit your representation.
Chief manager, human resource, NEPCO.
And you submit it within a certain period of time, and we'll ask this authority to consider and dispose of your representation within a time frame. That'll be better.
Yes. Already one representation is pending before deputy commissioner, my lord.
Deputy commissioner has no business to dispose of your representation.
I was of the impression that since the deputy commissioner has issued the advertisement, so deputy commissioner might have authority to consider my representation.
He will not have any authority to change the materials there, H bar or education. Supposing the NIPCO says that they should be master degree holder, can the deputy commissioner say no, bachelor will be enough? Can he say that? He cannot. He's only the requisitioning. He's been requisitioned by the NIPCO. Please understand that. That's why nobody is against you. Only thing is that you're not gone to the proper channel. You're coming through wrong channel. So this will create more confusion for you. Please write down. Mr.
R. Imam.
So and so learned counsel for the petitioner who submits that by filing this writ petition, the petitioner has sought for direction to the respondent authorities to consider his candidature for the post of junior engineer (civil), which was advertised on behalf of the NIPCO. By the Deputy Commissioner, Shiomi District, Tato. Rights are dated 6/2/2025. Stop. The learned counsel submits that since the petitioner is 37 years of age as on today, he has the apprehension that his application for the said post will be rejected. To stop, the learned counsel submits that the petitioner has tried his best to obtain necessary information from the respondent authorities concerned, but information could not be given to the petitioner as sought for. Stop. The learned counsel, however, submits that as per the age limit for appearing in the Arunachal Pradesh Public Service, age limit prescribed for appearing in the combined competitive examinations conducted by the Arunachal Pradesh Public Service Commission candidate who belongs to the scheduled tribe bracket APST no, I think let's rephrase the sentence again. He submits that from the cancel. Huh? The learned counsel submits that the age limit fixed for participating in the Arunachal Pradesh Public Service Combined Competitive Examination. The maximum age limit is 40 years for APST scheduled tribe. And therefore, the upper age limit prescribed by the said circular ought to have been 40 years. Stop. The learned counsel submits that although a representation was submitted by the petitioner to the Deputy Commissioner, Shiomi District, but the same has not been considered till date. Stop. He submits that a registered society namely the Bo Romo Bokar Welfare Society, page 105, had made a representation before the NIDCO authorities for making certain considerations for the scheduled tribe applicants, including job reservation and upper age limit relaxation on 28/2/2025. But the same has also not been considered. Stop. Having no alternative, the petition is before this court. Stop. Next para. The learned counsel has submitted that the circular dated 6/2/2025 has been issued by the Deputy Commissioner, Shiomi District, on a requisition made by NIPCO. And therefore, the Deputy Commissioner may be directed to consider and dispose of the representation filed by the petitioner. However, since it is NIPCO who had made the requisition in terms of their letter dated 13/1/2025, the petitioner ought to have submitted his representation to the NIPCO authorities. That is the Chief Manager, bracket Human Resource, NIPCO. Stop. Next para. Having regard to the apprehension made by the petitioner that his application will be rejected, and also the fact that the selection is likely to happen very soon. The petitioner is given liberty to file a representation with his grievance, with his prayer for relaxation of age. Before the Chief Manager, Human Resource NIPCO, within a period of
7 days.
7 days from today. Full stop. The said authority, upon receipt of such representation, shall consider the same and dispose of, shall consider and dispose of the same by way of a speaking order within a period of
7 days.
as expeditious as possible and preferably within a period of
Before recruiting the post in question,
before
recruitment of post in question.
further process of recruitment is being taken, is undertaken in terms of the circular dated 6/2/2025. With the above observation, in direction with petition stands this court. May I record your appearance?
Yes, for me and Mr. President. Not necessary, madam.
Okay.
Lordship, here I need some more time, Lordship, though this is pensionary matter, but then I need some more time.
You need some more time?
Yes.
Was retired on 31st October 2023, my lord. And as on today, pension is not paid.
Why
Is,
pension is not given? Because of NOC?
No,
No,
lordship.
NOC, everything is clear, my lord.
Lordship, his overwork has not been, Lordship, condemned, that's why, Lordship, because of that obstacle,
Overage.
overage. In the time of recruitment, Lordship,
Appointment.
appointment, I mean.
Overage at the time of recruitment,
Appointment, Lordship.
at the time of appointment.
Yes, Lordship.
So
Lordship,
you found out that he was overage only after his retirement. What is this? I don't know. I don't understand what you say.
Lordship, we have
Hmm?
we have read to the Commissioner of Transport, Lordship. We are awaiting instruction from.
No, what is seems to be the problem? What do you mean by overage?
Yes, it is in the petition itself.
Is it overstay in the service or something like that?
This says, my lord, it pays, my lord, kindly.
So if he was overage at the time of his appointment, what are you going to do about it? At this stage now? How much have you served? How many years?
31 years,
You have served for 31 years.
my lord.
And now they say that you have been appointed at the age of 38 years, 8 months, 14 days, and you are overage.
My lord, that is at the last moment, my lord.
And it took them more than 30 years to find out that you were overage.
That's what, my lord.
Huh? No, why you causing this kind of confusion?
Lordship,
That to a retirement days, my lord.
Lordship, we are taking instruction because the department is with him, Lordship.
Department is?
Department is with him, the transport department.
Transport is with him, of course. He's an employee of transport department for
Yes.
30 years.
Yes, the deputy GM has written to the Lordship, Commissioner. for
Commissioner
that-
Transport. He is not
Commissioner
acting
Transport,
upon.
Lordship. for condemnation of his age. So we are awaiting from a reply from the Commissioner Transport.
Director has written to the commissioner.
Yes, Lordship.
Commissioner can condone the age.
Yes, Lordship, in similar matter.
My lord,
Yeah.
page 109, my lord. So clarification, it was sought for, my lord, by the Secretary Transport. And in response to that, my lord, this was written by General Manager, State Transport Service,
Yes, General
dated
Manager.
11 July 2024. This is the crux, my lord. Forwarding of clarification.
All right, you take some more time. Let them have the instructions. All right. What can be done at this
Yes,
stage?
Lordship.
This is, my lord, pension matter. Some due and urgent consideration, maybe, my lord.
When did you file the?
My lord, it was on 20 January 2025. my
Wow,
lord.
in January only.
Yes, Lordship, this is third time only. Second time only.
When did you retire?
31st August 2023, my lord.
23.
23, my lord.
Earlier you filed writ petition also.
No, my lord.
This is the first writ petition.
First writ petition, my lord. I have
So
been
after retiring in
filing-
2023, you file a case in 2025 and you say it's very urgent.
my lord, representation thereafter, legal notice.
Another senior government advocate, additional senior government. She may be given further 2 weeks time to obtain instructions and to file counter affidavit in the matter.
Lordship, 3 weeks for to be on safer side.
3 weeks time, okay. Counsel for the petitioner otherwise expresses urgency, since the petitioner has already retired from service in the year 2023.
My lord.
Considering the submissions made, 3 weeks time is granted to the respondents with an understanding that instructions will be forthcoming by the next date, so that court can consider disposing of the matter
My lord.
on the next date.
Highly obliged.
Obliged.
May I please, my lord?
Yes.
Day before yesterday, instruction was short for, my lord, this is the stone crusher matter.
Stone crusher.
My lord, I'm told that no instruction had been received.
We
So, my
have-
lord, this is
Your
my
Lordship,
7th appearance. That's
We
what-
have received, but we have not received we have received instruction, but not clear instruction from this one, Your Lordship, Green Tribunal.
What do you mean? We have received, but it is, we have not received clear
We
instruction.
have not received a clear instruction, Your Lordship.
What instruction have you received?
They have only
My lord, in the last occasion, my lord has expressed that my interim will be considered today.
No, this is in the month of May last year.
Yes, sir, no clear instruction, Your Lordship. But through telephonic, they inform us there is no any other development, only notice was issued, Your Lordship. No update, Your Lordship, in this case.
Is there any stay order from the Green Tribunal?
No, Your
No, my
Lordship,
lord,
no, Your
that
Lordship.
at least, my lord, I honestly submit, there's no such stay of operation.
Now, thing
And
is
Your
that,
Lordship, in this matter, AAG Aris Nabam is appearing.
now, if the interim order is granted to you, that would be overreaching the final
No, my lord.
relief that you're praying for.
No, my lord, I am at the
Main
loss.
thing, See, main thing is you want to operate the stone crusher
My lord,
and you have been prevented from using that.
for the last 7-8 months, my
So
lord,
that is why you've come to this court.
my lord.
Now, if we say that you let him be allowed, then what else remains?
My lord, at the outcome of the PIL and NGT decision will decide my fate. Why such peculiar order from the one of the party respondent? That is my grievance, my lord. My commonness of sense, my lord. How come this order when our honorable High Court as well as NGT Kolkata themselves had not issued any such orders?
What is the order passed at the PIL?
My lord, just notice was issued. An affidavit have been exchanged. It is also at the final stage of hearing. They have also filed their rejoinder also, the petitioners. The PIL has been attached with the instant writ petition is because what is the reply of this respondent number of the Geology and Mining Department, which is also in my favor. In their affidavit in opposition, they have also clearly indicated that even if there is any anomalies, this is just a guideline. So a little deviation from the guideline will not be considered as full defect of allowing me to permit the business of stone crushing. That is there in their affidavit. At this stage, I will humbly pray that let their instruction and clear instruction come up. Till then, my interim may be considered. At least let me do some business, my lord. Till the outcome of the PIL and the case of the NGT Kolkata.
Here, we have received
This, who has given you this?
Deputy Commissioner.
Hmm?
But we have seek instruction from Secretary of Lots of Geology and Mining.
My lord, if I may submit, my lord, presumption can also be done, my lord. I have moved this matter on 21st of January this year, and today is 12. My lord, office is at Itanagar. How far is it for an instruction to be issued? So, my lord, they are deliberately not issuing any instruction. I believe it is in my favor. Since 21st of January, when I first moved this petition, my lord. Since then, my lord, may kindly peruse all the orders. The court has been asking for instruction all this time, and now this is month of March. When will I work, my lord? Either at least they can issue some instruction. They were just, the honorable court issued only for the instruction, and still till date, they have not received the instruction. Private respondent.
You are the private respondent.
Yes.
What is the proceeding in the PIL? Have you filed anything?
My lord, we have already exchanged our pleadings. It is, even the applicants have filed a rejoinder. So it is at the final stage of hearing, my lord.
Let the PIL be heard instead, I think.
My lord, interim relief, my lord, at least I
No,
will.
no. See, since the number one is the PIL is taken up by division bench. Secondly, the Green Tribunal is also looking into it. And of course, your writ petitions is also pending at the same time. But since the subject matter is the same thing, I think it'll be better if it should be taken up by the division bench.
It will cast a doubt in the integrity of my profession, of my client, my lord. My lord, they will cast me. It has been 7th hearing, my lord, and instruction upon instruction, and still I'm not getting any relief, my lord.
Client may want anything. We don't go by what the client wants, you see.
My lord.
You know the procedure very well. When two matters are pending of the same issue, before waiting for the division bench to take a call on a single bench come and say that do this, do that, they will not be proper. Since you have a regular division bench, let it come up in the coming week to see what can be done.
My lord, then what will happen to the fate of this writ petition, my lord? This instant writ petition, my lord.
Will remain. So whatever orders to be passed in the PIL will have a bearing on the writ petition also. Since you are a respondent there also, it's not that you're not being heard. You are a party to that proceeding also. I'll direct it to be placed before the DB, next DB, next week.
Okay.
And you complete your instruction in the meantime if you want to.
Okay, that's it.
That's the only recourse I can do at this stage. I understand your problem. You've got a lot of things. For the last few months, you're not having this thing. And for what reason? But let it be taken up appropriately. Registry to list the matter. So, just cancel that. You say that since what is the house it listed today?
My lord.
Since the instant writ petition is connected with the PIL, which is taken up by a division bench of this court, registry shall place the to be constituted from the week commencing from 17th of March 2025.
But can it be on 19th? 17th, my lord, I'll have a matter on other court. 19th, Wednesday.
Okay.
19th of March.
Registry to release the matter before the division bench, preferably on 19th of March 2025. Yes.
My lord,
Lordship, we'll file our affidavit.
You have filed.
No, Lordship, we'll file.
You'll file.
No, Lordship, we'll file.
When will
I
you
have
file?
received the instruction, Lordship, now.
will you
Full
file?
Instruction day before yesterday. Lordship.
Ms. G. Atel, Learned, Additional Senior Government Advocate, appearing for the state respondent, submits that she has received the Paravest comments and prays for 2 weeks' time. To
2
file
weeks,
the-
Lordship.
my lord, I have filed an additional affidavit, my lord. Showing that the construction is still taking place in my private
Lordship,
land.
this is allotted place. Of course, construction will take place, Lordship. This was allotted to the SIB or SSB in the year 1987, Lordship.
My lord, in
We
my
have the
fair,
allotment order also, Lordship. Allotment by the government to this SSB in 1987, Lordship.
my lord, in my paragraph 5.
Anyway, let them file the affidavit, we'll see.
Yes.
The affidavit is filed.
My lord, since the construction is in full swing and my all plantations and bamboo groups are being uprooted
Lordship, that is-
during this period. So at least a status quo as on that may be granted, my lord.
Lordship, since 1987, it is under the possession of SSB, and then afterwards from 2005, it has come to the possession of SIB now. How there can be a plantation and all, Lordship?
My lord, may kindly come
He
to
had
paragraph 5 of my.
somehow obtained the LPC, one of the petitioner have obtained the LPC in 2018, Lordship. 1987 and 2018, Lordship, just.
My
And
lord,
some LPCs are Lordship, without saying the obtained fraudly.
that is
An
very.
interim order was passed.
No, my lord,
No, Lordship.
my lord,
That's why-
interim was passed, supposed to be passed today, but wrongly that the order that said on last order,
Says
it is
interim order
mentioned that
personnel shall
yes, my
continue
lord.
till the next day.
That's the reason, my lord, I am
Yes,
checking for the
Lordship.
interim status. My lord, I have already categorically mentioned in my petition paragraph 5, my lord, I am not disputing the land to the fact that the land is allotted to the respondent
See,
number
we'll
6.
do one thing, we'll give you some time. You have received your Paravest comments.
Yes,
When can you file it?
Lordship, next week I'll file. Lordship.
Next week. So we'll list it next week then. When can you file it? Today is 12th.
Lordship, let it be by 19, I will file 18.
Please cancel the order. Ms. G. Atel, Learned, Additional Senior Government Advocate, submits that she has received the Paravest comments and will be able to file the same by 19th of March 2025. Stop. Learned Counsel for the petitioner, on the other hand, has pressed for the interim order, submitting that construction is going on full swing in his land, and therefore he will be adversely affected. To stop considering the submission made, list this matter on 20 of March, 20 or 21st, 21st of March. Of 20
21st.
21st of March 2025.
Lordship.
It is also observed that if affidavit is not filed before the next date fixed, the petitioner is at liberty to press the interim order, press for the interim order on the next date.
Lordship.
Esteemed Lady, Your Lordship. In this writ petition, this is for the revocation of suspension order. Suspension order was not reviewed within 90 days. And Your Lordship, on 4/2/25, direction was the respondent. Yes, respondents were directed to get instructions in regards to the release of subsistence allowance, which the petition has not yet received after suspension, after the even 6 months. He is without subsistence allowance.
Yes, what is?
My lord, regarding subsistence allowance, he's being paid, my lord. There's no issue quarrel on the subsistence allowance. But so far, my lord, the review part is concerned, my lord. As per instruction, my lord, the review has not been done so far.
How many days have passed?
It's almost six, your lordship,
Order date of suspension is?
suspension is 11/8/2024. So almost 170, 180.
28.
Yes.
What do you mean by yes? Which date?
Uh,
11th August or 20th?
11 August 2024.
Page
21 August. No. It's written as 20 August 2024.
Suspension.
Issued on 21. Order is written as in top.
No, it's
11
it's
August.
11 August.
No.
Page 17.
Issued on 20, madam.
Issue on 20, yes, as per the digital signature. Well, it can be,
sorry,
if standing council is admitting that review is not done, then as per the CCS rules, if not done under
Whether-
sections 10 of 6 of CCS rules.
One case is there, I think Ajay Chaudhary or something.
Yes, the judgment is, just take the judgments.
You have been suspended with effect from which date?
Judgment is Ajay Kumar Chaudhary, Your Lordship.
Yes, with immediate effect. Immediate effect means which date? 11th or 20th?
Whether he was arrested or not, that is another issue.
No, he is not arrested. There's only allegation that he was in conspire with the.
Okay, you say you have not received subsistence allowance. He says he have received it.
Subsistence allowance, it's no dispute, my lord. Maybe he has not been informed. On a written instruction, it shows subsistence allowance is being paid. And so far, whether he has been arrested or not in this connection, my lord,
Well,
that is their-
I'll pray that he can file a short affidavit and it can be disposed of because
if he's arrested, my lord, that when he released, but that is relevant, my lord. That because 90 days, my lord, that will count from date of his release from the custody, my lord. So if he's released,
See, none of you are clear with the facts. How do you expect the court to decide?
no, he has not been arrested. Your
You
Lordship.
say you have received subsistence allowance. Mr. Tagum says you have received it.
Now, as per my client's instruction,
There are 2 dates in the suspension order. Everything is here and there.
my lord, as per the client's instruction, he said that subsistence allowance not what paid. Maybe they have issued recently that we are paying the subsistence.
regarding this, my lord, whether he has been arrested or not, this we need instruction, because if he's arrested, my lord, the date of release would be relevant.
So why is it fixed today? For what?
Only but regarding.
I think he has also got the instructions that you're getting it. Maybe you are not getting the up-to-date instructions.
I will get back.
Mm.
I will get instruction from my client, Your Lordship.
List the matter again next week.
Next week. Date may be fixed, Your Lordship. Till then, my lord, respondents can file affidavit and it can be disposed of.
Next date, my lord, it's just for instruction, my lord, only regarding, my lord, whether he has been arrested or not. If he's arrested, my lord, he'll be the appropriate person to give, my lord, the relevant information when he was released on bail, my lord. That is only one. But so far subsistence allowance is concerned, it is confirmed, my lord.
Okay. Please write, list the matter again on 20th of March 2025 as paid for. Mr. S. Maul, learned counsel for the petitioner, shall inform the court as the petitioner has received the subsistence allowance or not. since Mr. T. Tagum, learned standing counsel. Which department?
Education Department.
Education Department submits that the petitioner is being given subsistence allowance. The learned counsel for the petitioner should also inform the court as to whether the petitioner had been arrested at any point of time. And if so, when was he released? So that the court can proceed with the matter. Okay.
My lord, I will also pray that he can file, respondent can file affidavit.
My lord, if it is that affidavit is not required at all, my lord. Instruction I have got. my lord.
If that instruction is, they can dispose it of.
Exactly.
That can be done.
All right. So affidavit, he doesn't want to, if he wants to file, let him file. He doesn't want to file, we'll dispose it of nevertheless.
My lord.
Those two informations should be there.
Okay.
Then you can bring your Ajay Kumar Chaudhary also that day. Okay.
Then
On
the
that
date
basis,
they may.
prolonged suspension without review will have to be looked into. All
Then,
right.
my lordship, date may be fixed. Your lordship.
I've already fixed it.
28.
Your mind was somewhere else. I fixed 20th of
38th, okay.
March. Next case, please.
Obliged.
My lord, my affidavit is ready.
Please,
Only, my lord,
Ready but not filed.
my lord,
Ready, but it is not filed.
my lord, only the duty depends on the part of the matter, the annexures, my lord.
When
There
can
is
you
so
file
many-
it? When can you file?
My lord, within this week,
Huh?
it can be filed, my lord.
Sorry?
Within this week, my lord, it can be filed,
Within this week means tomorrow.
my lord. Tomorrow, my lord.
Day after, nobody is coming to court.
My lord.
Your lordship, it may be fixed on 20 because 20 of March, because due to non-file affidavit, the petitioner is suffering. He is not being allowed to resume his duties since from
We'll fix on 20.
20.
My lord.
Okay, parties are represented by the respective councils. Mr. M. Katol and at DSGI submits that the affidavit in a position of the respondent Union of India will be filed within the course, within this week.
By 19, till, matlab, up to 19 months.
See, again, you're extending, you said it will be filed.
Or 18, my lord, till 2 days time for reply if any. my lord.
Will be filed by 18th of March 2025. You list the matter on 20th of March as paid for.
My lord. DPW.
My lord, here I need some more time, my lord. I sought for instruction, my lord. Instruction I could not receive urgent today.
Time for what?
For filing affidavit, my lord. This is regarding the non-issuance of clearance, my lord. It's actually
much
the
time?
vigilance.
How much
My lord,
time?
3 weeks, my lord.
As paid for by the council for respondents, further 3 weeks time is granted to obtain instructions and to file counter affidavit.
DPW.
My lord, I may be allowed to take fresh step upon respondent number 4, my lord.
What do you mean by fresh steps?
My lord,
You have not taken steps
Yes,
for
madam.
once also in the first place. How did you say fresh steps?
then my lord, I may be allowed to take steps upon respondent number.
How much time? Within 3 days?
Within a week, my lord, because my lord, postal stamp is not available in Arunachal, my lord, right now.
Sorry?
Postal stamp is not available.
Postage time is not. So from where you
I
get?
am facing difficulties since last week, my lord.
What postage stamp? Postal stamps?
Yeah, stamps.
Not court fee stamps.
Postal.
Postal stamps.
Yes, yes.
How many post offices there? Itanagar, Nahalagun also is there.
Yes, in
Sub
all
post
places.
office.
my lord.
All the post offices are not having stamps.
Yes, my lord. I have searched
Then
all.
how they're functioning without postage stamp?
Yes.
Anyway, counsel for the petitioner prays for and is granted a week's time to take steps for service of notice upon respondent 4. In terms of the court's order dated 12/11/2024. Since November, you have been looking for postage stamps. You go to Guwahati, you'll get plenty there. Okay. 24. Who is respondent number 8 and 9?
My lord, this case, based on this case, work was stopped. Then the other parties, this respondent number respondent 8 approached this court. Then in the meantime, they have instructed they are agreed to not to disturb each other. So on instruction, that case was disposed. And I am verbally told that they have already settled the matters, parties. This nurse, who was the complainant?
Do you agree with that?
But he have no instruction.
Lordship, my client is not clear instruction, Lordship. Matter may be released after a week, Lordship.
Mr. G. Tarak, learned counsel for the standing counsel for the RWD submits that the private respondents and the petitioners have already settled their disputes.
Yes.
However, Mr.
Honi Tanatara, Lordship.
Oni
Tanatara. Honi Tanatara, Lordship. I for petitioner, Lordship.
learned counsel submits that he has no instructions in this regard. Ishti Tara, Honi Tara is there. Then what about the, okay, then when do you want it? When do you want it?
Lordship.
When shall we list it?
Lordship may be released after a week, Lordship.
Okay, list this matter again after a week. In the meantime, let service report be awaited from respondent numbers 8 and 9.
Deeply, Lordship.
These matters were otherwise fixed for disposal. Today, obviously, it will not be possible. We have all agreed on 24th, madam, if it is not inconvenient. And on this matter, we have already filed our detailed affidavit in the main petition.
Pleadings are exchanged from the petitioner and the respondent.
There is already an observation that it will be taken up for disposal. In the admission column.
24.
24.
What are these matters otherwise?
Tender matter.
Tender matter.
Tender, okay. Any interim?
Yes, there is an interim.
Running in favor of the petitioner?
Yes.
And in fact, that is what is the urgency. It's a rural electrification project which has been stalled because of
Okay, parties are represented by the respective councils. And as agreed upon, let the matter be listed on 24 March 2025. On which date an attempt shall be made to dispose of the petition.
For admission, my lord.
Let it be listed for admission.
Matter be listed in the admission column. Interim order passed earlier shall continue till the next date.
Grateful.
Obliged.
27.
27 is also a tender matter, my lord. Here, respondent has not yet filed their affidavit.
Any interim order here?
Yes, my lord. 24-2.
Which respondent is not filed?
The
My
state
lord, I have
respondent.
yet to receive
Department.
instruction. Let the matter be take up on 28.
Okay, as paid for by Mr. G. Tarak, learned counsel.
28. 24 ko leave.
24.
What is standing
Okay,
counsel?
24, I'm coming for some matter, my lord, to your lordship. We can fix it on 24.
24 yes.
Learned standing counsel, rural works department. List the matter on
24.
24th of March 2025. Respondents to file their counter affidavit in the meantime.
Okay.
Interim order may be done.
Interim order passed earlier shall continue till the next date of listing.
Okay.
That's all.
Grateful, man.